All right, everybody. Justice is the Process is here, and we are here for Verdict Watch Day. And getting a little bit of a later start than what I wanted, but we are going to jump into the courtroom here and watch the jury charge. I'll be viewing it mobily, but I wanted to jump in here and say hi. Um, but we are on verdict watch day. Right now, the jury is deliberating as we speak. No verdict to speak of. When a verdict does come, we will jump on, talk about whatever the verdict is. Some of you may have seen, I hope if you haven't, jump over and look at it. I put a video out this morning speaking about what I think the verdict will be and gave some analysis on the case, broke down the case as the state put up a very nice presentation of summary of witnesses. I go over those, played a few clips from the defense attorney's closing, and went over why I believe the jury will ultimately find Jennifer Crumbley not guilty. That is my opinion. I am of the opinion that the defense attorney did a good job in this case. I think some people didn't understand her approach, but once I saw the closing, once I understood what she was trying to convey to the jury, I understood now why she was so emotional, why she was trying to, um, you know, not afraid to make light of the mistakes she was making. Obviously, not everything she did is going to come across to would resonate well. And she apologized for some of those things, like some of the statements she made. But the ultimate flavor was she's a regular person who makes mistakes, but that doesn't make her someone who would be a grossly negligent parent. And that was the same issue, which saying, hey, Miss Crumley's not the most likable person. She's not a perfect individual. She's got aspects of her life you would disagree with, but none of that means she would be a grossly negligent parent who wouldn't care about a school shooting happening, or if she believed it was something that was foreseeable, that she wouldn't have taken steps to have prevented a school shooting. Anyways, that's where we're at with this. I think it's going to resonate with this jury. I believe if she was being that she is a very competent attorney, a very well-renowned attorney, I believe she was playing to the jurors that she picked, that she believed would um, that would resonate with. And given the fact that the community that, she talked about in her closing argument, that this was a community that is a gun owning community, I believe that that's going to be a significant fact, because the state is essentially making the argument that ownership of a gun is some sort of trigger, some sort of of, uh, of a exigent circumstance that would make the parents be on alert and have them processing their child differently in all aspects, and that they should be assuming that because they're gun owners, their child could be the next school shooter. And I don't think that's going to be the way they're going to process things. But we're going to jump in here. Like I said, we're going to watch the jury charge, watch the jury get turned over to deliberate, and then if something comes up, if there's a verdict somehow in between us watching this, we'll jump to live, of course, and watch it. But I don't think this is going to be a super long deliberation. It could be. I think if it's the longer it goes, obviously, I believe will be better for the defense, because I think it would mean that there was maybe one or two people back there that are just struggling with letting her walk out of the courtroom completely. But I really do believe these jurors are going to come to the final conclusion of not guilty, and she's going to be found not guilty of all four. Now, the dad is in a different situation, as I bring up in that video, because he was the guy that was the owner of the guns. He was responsible for the guns, and there's going to be a separate argument that you can make that says, well, if this jury believes that he didn't appropriately secure his firearms, now you have a totally different theory of the case that could lead to a guilty verdict. And there may be Again, we don't know because we haven't seen that trial yet, but I'm giving the state the benefit of the doubt that there might be some evidence that couldn't come in against her because, again, there was not very much evidence at all against Jennifer Crumbley, but maybe there's evidence that they can say shows he wasn't being as judicious with his protection of the firearms in the household. So let's jump into the courtroom here, take a look at it, and go from there. So give me one moment.
Case number 22279990 FH.
Good morning, Your Honor. Karen McDonald on behalf of the people.
Thank you, Marquise, on behalf of the people.
Good morning, I'm Shannon Smith on behalf of Jennifer Crumbley, who sits to my left.
Good morning. I think a couple things. I sent you an email over the weekend.
Thank you.
Regardless of the verdict in this case, we agreed that the gag order will stay in place until after the trial of James Crumbley. Is that
Yes.
correct?
That's correct.
All right. Can you approach on another manner? You both have copies of the jury instructions?
Yes, sir.
Okay, so I'm going to sign copies of them as well.
Yes, thank you.
They told them to bring all of their personal belongings. That's why it's taking a little bit of time.
All rise for the jury.
Good morning, you may be seated. You've all been so wonderful and timely that I have another jury starting next Monday, and I'm wondering if you'll all be willing to come back next week. No? Hard no? I'm going to read you some jury jury instructions. You're gonna get a written copy of these in the jury room. Then I'm going to pick 5 of you by random who are going to be alternates. I know that you've all been in 2 different jury rooms, so when you're brought together, it's going to be like the show Survivor when the teams are merged, right? The tribes are merged, right? So I know you've been in 2 different jury rooms, but we'll be putting keeping the 5 alternates still sequestered in Judge Anderson's jury room, and the 12 will be in my jury room. That's why I asked you to bring your personal belongings when you came in here, right? Members of the jury, evidence and arguments in this case are finished, and I'll now instruct you on the law. That is, I'll explain the law that applies to this case. Remember that you have taken an oath to return a true and just verdict based only on the evidence and my instructions on the law. You must not let sympathy, bias, or prejudice influence your decision. You must avoid reaching conclusions that may have been unintentionally influenced by stereotypes. You must reach your own conclusions about this case individually, but you should do so only after listening to and considering the opinions of the other jurors who may have different backgrounds and perspectives from yours. As jurors, you must decide what the facts of this case are. This is your job and nobody else's. You must think about all the evidence and then decide what each piece of evidence means and how important you think it is. This includes whether you believe what each of the witnesses said. What you decide about any fact in this case is final. It's my duty to instruct you on the law. You must take the law as I give it to you. If a lawyer says something different about the law, follow what I say. At various times, I've already given you some instructions about the law. You must take all of my instructions together as the law you are to follow. You should not pay attention to some instructions and ignore others. To sum up, it's your job to decide what the facts of the case are, to apply the law as I give it to you, and in that way to decide the case. A person accused of a crime is presumed to be innocent. This means you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty, unless you're satisfied beyond a reasonable doubt that she is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of crime beyond a reasonable doubt. The defendant is not required to prove her innocence or to do anything. If you find that the prosecutor has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that's reasonable after a careful and considered examination of the facts and circumstances of this case. When you discuss the case and decide on your verdict, you may only consider the evidence that has been properly admitted in this case. Therefore, it's important for you to understand what is evidence and what is not evidence. Evidence includes only the sworn testimony of the witnesses, the exhibits admitted into evidence, and anything else I told you to consider as evidence. Many things are not evidence, and you must be careful not to consider them as such. I'll now describe some of the things that are not evidence. The fact that the defendant is charged with a crime and is on trial is not evidence. Likewise, the fact that she is charged with more than one crime is not evidence. The lawyer's statements and arguments and any commentary are not evidence. They're only meant to help you understand the evidence and each side's legal theories. You should only accept things the lawyers say that are supported by the evidence or by your own common sense and general knowledge. The lawyer's questions to the witnesses, my questions to the witnesses, are also not evidence. You should consider these questions only as they give meaning to the witnesses' answers. My comments, rulings, questions, and instructions are also not evidence. It's my duty to see that the trial is conducted according to the law and tell you the law that applies to this case. However, when I make a comment or give an instruction, I'm not trying to influence your vote or express a personal opinion about the case. If you believe that I have an opinion about how you should decide this case, you must pay no attention to that opinion. You are the only judges of the facts, and you should decide this case from the evidence. At times during the trial, I've excluded evidence that was offered or stricken testimony that was heard. Do not consider those things in deciding the case. Make your decision only on the evidence that I let in and nothing else. Your decision should be based on all of the evidence, regardless of which party produced it. You should use your own common sense and general knowledge in weighing and judging the evidence, but you should not use any personal knowledge you may have about a place, person, or event. To repeat once more, you must decide this case based only on the evidence admitted during this trial. As I said before, it's your job to decide what the facts of this case are. You must decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness said. You're free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a person's testimony, you must set aside any bias or prejudice you may have based on a witness's disability, race, national origin or ethnicity, gender or gender identity or sexual orientation, or religion, age, or socioeconomic status. Again, take the time you need to test what might be automatic or instinctive judgments and to reflect carefully about the evidence. There's no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Did the witness seem to have a good memory? How did the witness look and act while testifying? Did the witness seem to be making an honest effort to tell the truth, or did the witness seem to evade the questions or argue with the lawyers? Does the witness's age or maturity affect how you judge his or her testimony? Does the witness have any bias, prejudice, or personal interest in how the case is decided? Have there been any promises, threats, suggestions, or other influences that affected how the witness testified? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does a witness's testimony seem when you think about all of the other evidence in the case? Sometimes the testimony of different witnesses will not agree, and you must decide which testimony you accept. You should think about whether the disagreement involves something important or not, and whether you think someone is lying or is simply mistaken. People see and hear things differently, and witnesses may testify honestly, but simply be wrong about what they thought they saw or remembered. It's also a good idea to think about which testimony agrees best with the other evidence in the case. However, you may conclude that a witness deliberately lied about something that is important to how you decide this case. If so, you may choose not to accept anything that witness said. On the other hand, if you think the witness lied about some things but told the truth about others, you may simply accept the part you think is true and ignore the rest. James Robert Crumbley and Jennifer Lynn Crumbley are both on trial in separate cases. The fact that they are both charged is not evidence that either one is guilty. You should only consider the evidence presented in this case. Each defendant is entitled to have his or her case decided on the evidence and the law that applies to him or her. The prosecutor must prove beyond a reasonable doubt that the crimes occurred on or about November 30th, 2021 within Oakland County. The prosecution has introduced evidence of a statement that it claims the defendant made. Before you may consider such an out-of-court statement against the defendant, you must first find that the defendant actually made the statement as given to you. If you find the defendant did make the statement, you may give the statement whatever weight you think it deserves. In deciding this, you should think about how and when the statement was made, and about all the other evidence in the case. You may consider the statement in deciding the facts of the case, and in deciding if you believe the defendant's testimony in court. Facts can be proved by direct evidence from a witness or an exhibit. Direct evidence is evidence about what we actually see or hear. For example, if you look outside and see rain falling, that's direct evidence that it's raining. Facts can also be proved by indirect or circumstantial evidence. Circumstantial evidence is evidence that normally or reasonably leads to other facts. So, for example, if you see a person come in from outside wearing a raincoat covered with small drops of water, that would be circumstantial evidence that it's raining. You may consider circumstantial evidence. Circumstantial evidence by itself, or a combination of circumstantial evidence and direct evidence, can be used to prove the elements of a crime. In other words, you should consider all the evidence that you believe. There has been some evidence the defendant ran away and tried to hide after she was accused of the crimes. This evidence does not prove guilt. A person may run or hide for innocent reasons, such as panic, mistake, or fear. However, a person may also run or hide because of a consciousness of guilt. You must decide whether the evidence is true, And if true, whether it shows that the defendant had a guilty state of mind. You have heard evidence that before the trial, a witness or witnesses made a statement that may be inconsistent with his or her testimony here in court. You may consider an inconsistent statement made before the trial only to help you decide how believable the witness or witness's testimony was when testifying here in court. If the earlier statement was made under oath, then you may also consider the earlier statement as evidence of the truth of whatever the witness and or witnesses said in the earlier statement when determining the facts of this case. When the lawyers agree on a statement of facts, these are called stipulated facts. You may regard such stipulated facts as true, but you're not required to do so. You should not decide this case based on which side presented more witnesses. Instead, you should think about what each witness, about each witness and each piece of evidence and whether you believe them. Then you should decide the case. Then you must decide whether the testimony and evidence you believe proves beyond a reasonable doubt that the defendant is guilty. You've heard that a lawyer or lawyer's representative talk to one of the witnesses. There's nothing wrong with that. The lawyer or lawyer's representative may talk to a witness to find out what the witness knows about the case and what that witness's testimony will be. You've heard testimony from witness Detective Edward Wagrowski, who has given you his opinion as an expert in the field of forensic cell phone analysis. Experts are allowed to give opinions in court about matters they are experts on. However, you do not have to believe an expert's opinion. Instead, you should decide whether you believe it and how important you think it is. When you decide whether you believe an expert's opinion, think carefully about the reasons and facts they give for their opinion and whether those facts are true. You should also think about the expert's qualifications and whether their opinion makes sense when you think about the other evidence in the case. You've heard testimony from witnesses who are police officers. That testimony is to be judged by the same standards used to evaluate the testimony of any other witness. In count 1, the defendant is charged with the crime of involuntary manslaughter. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant caused the death of Madison Baldwin. That is, that Madison Baldwin died as a result of storing a firearm and its ammunition so as to allow access to the firearm and ammunition by her minor child. Second, in doing that act caused Madison Baldwin's death, the defendant acted in a grossly negligent manner. In count 2, the defendant is charged with the crime of involuntary manslaughter. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, the defendant caused the death of Tate Meir. That is, that Tate Meir died as a result of storing a firearm and its ammunition so as to allow access to the firearm and ammunition by her minor child. Second, in doing the act that caused Tate Meir's death, the defendant acted in a grossly negligent manner. In count 3, the defendant is charged with the crime of involuntary manslaughter. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant caused the death of Hannah St. Juliana. That is, that Hannah St. Juliana died as a result of storing a firearm and its ammunition so as to allow access to the firearm and ammunition by her minor child. Second, in doing the act that caused Hannah St. Juliana's death, the defendant acted in a grossly negligent manner. In count 4, the defendant is charged with the crime of involuntary manslaughter. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant caused the death of Justin Schilling. That is, Justin Schilling died as a result of storing a firearm and its ammunition so as to allow access to the firearm and ammunition by her minor child. Second, in doing the act that caused Justin Schilling's death, the defendant acted in a grossly negligent manner. As I explained earlier in my instructions, the prosecutor asserts two different theories to support the charges of involuntary manslaughter. First, the prosecutor claims that the defendant committed involuntary manslaughter because she failed to perform a legal duty. In the alternative, the prosecutor claims that the defendant committed involuntary manslaughter because she was grossly negligent. Those theories are two different ways to prove the same crime. Either or both of these theories, if proven, are sufficient to establish the crime of involuntary manslaughter. It's not necessary that you all agree on which theory has been proven, as long as you all agree that the prosecutor has proved at least one of those theories beyond a reasonable doubt. In count one, the defendant is charged with the crime of involuntary manslaughter resulting from a failure to perform a legal duty. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant had a legal duty to Madison Baldwin. The legal duty charged here is one imposed by law. In Michigan, a parent has a legal duty to exercise reasonable care to control their minor child so as to prevent the minor child from intentionally harming others or prevent the minor child from conducting themselves in a way that creates an unreasonable risk of bodily harm to others. This duty arises when both of the following are true. A, the parent knows or has reason to know that they have the ability to control their minor child. And B, the parent knows of the necessity and opportunity for exercising such control. Second, that the defendant knew of the facts that gave rise to the duty. Third, that the defendant willfully neglected or refused to perform that duty, and her failure to perform it was grossly negligent to human life. Fourth, that the death of Madison Baldwin was directly caused by defendant's failure to perform this duty. That is, that Madison Baldwin died as a result of the defendant's failure to exercise reasonable care to control her minor child so as to prevent the minor child from intentionally harming others, or the minor child from so conducting himself so as to create an unreasonable risk of bodily harm to others when the defendant knew that she had the ability to control her minor child and knew of the necessity and opportunity to do so. In count two, the defendant is charged with the crime of involuntary manslaughter resulting from a failure to perform a legal duty. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant had a legal duty to take mere. The legal duty charge here is one imposed by law. In Michigan, a parent has a legal duty to exercise reasonable care to control their minor child so as to prevent their minor child from intentionally harming others or prevent the minor child from conducting themselves in a way that creates an unreasonable risk of bodily harm to others. This duty arises when both of the following are true. A, the parent knows or has reason to know that they have the ability to control their minor child. And B, the parent knows of the necessity and opportunity for exercising such control. Second, that the defendant knew of the facts that gave rise to the duty. Third, that the defendant willfully neglected or refused to perform that duty, and her failure to perform it was grossly negligent to human life. Fourth, the death of Tate Meir was directly caused by defendant's failure to perform this duty. That is, that Tate Meir died as a result of defendant's failure to exercise reasonable care to control her minor child so as to prevent the minor child from intentionally harming others or the minor child from so conducting himself so as to create an unreasonable risk of bodily harm to others when the defendant knew that she had the ability to control her minor child and knew of the necessity and opportunity to do so. In count three, the defendant is charged with the crime of involuntary manslaughter resulting from a failure to perform a legal duty. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, the defendant had a legal duty to Hannah St. Juliana. The legal duty charge here is one imposed by law. In Michigan, a parent has a legal duty to exercise reasonable care to control their minor child so as to prevent the minor child from intentionally harming others or prevent the minor child from conducting themselves in a way that creates an unreasonable risk of bodily harm to others. This duty arises when both of the following are true. A, the parent knows or has reason to know that they have the ability to control their minor child, and B, the parent knows of the necessity and opportunity.
One thing that's just coming to mind as I'm listening to the jury instructions right now, and that is an interesting conflict that I think exists and that I think the defense should have been able to argue. And that is this. The state is essentially having their cake and eating it too. They charged Ethan Crumbley as an adult. And their choice to charge him as an adult, in my opinion, would negate and trump the idea that the duty of care exists. In other words, if he was being handled as a juvenile and it was being acknowledged, again, juvenile courts exist for the sole purpose that we acknowledge the difference between adult and child. The state here has said, no, Ethan Crumbley's crime and his actions in this case rise to a level that he should no longer be viewed. He shouldn't be viewed as a minor in relationship to the crime he committed. So as a result, we're waiving his juvenile rights. We're moving him to adult court, and we're holding him accountable as an adult because he acted as an adult. In other words, he acted in such a way that the juvenile courts is an inappropriate place to handle him, and that he acted on his own. And I mean, that's essentially how we have to view this. Then the state turns around and says, nope, for purposes of his parents, we're going to acknowledge that they had a duty of care. They could have prevented him, that he was an immature child in need of care from his parents. In my opinion, that is a conflict of the evidence that should have been allowed to have been argued by the defense. I'm sure that there was a motion in limine that I don't know because I haven't seen all the pleadings in this case, but I'm quite certain the state probably addressed that and said the defense couldn't make that argument as an affirmative defense. But in my opinion, when you're arguing a duty of care, the state itself has acknowledged there's a reasonable doubt with the fact that they chose to prosecute him as an adult, lock him up as an adult, and acknowledge that he was acting as an adult, that he was mature enough to act as an adult in this case, and that there was that essentially the duty of care that would have been present, that would have been needed because of his immaturity, because of the fact that that there would have been a responsibility of the parents to have been there to address his mental health needs and things of that nature, no longer exist. Because again, the state acknowledged it. This is a case where the facts, circumstances, and situation rise to a level that is beyond the normal juvenile case. So I think that, in my opinion, that is an area that I believe the defense should have been able to argue, because I think that's significant. Secondly, these jury instructions are quite confusing because the judge, and again, I guess I'm sure there was some debate over it and discussion over it, but the fact that the judge reads off that this is a case about storage of a firearm, that's how it reads in. We needed to make sure, and if I was the defense attorney, knowing that this was how the instructions were going to be read, it very much sounds like this is a case that originates from the storage of a firearm, and then that the first finding has to be that she had some sort of responsibility over whether or not he had access to that firearm. And if the jury finds that she wasn't responsible for the firearm, that she had no link to him having access to the firearm, and that her belief was that the firearm was secured, then we stop everything and we're not guilty. The way I'm listening to this jury instruction is, the first step is, do we believe she was responsible in some way for keeping that firearm out of his hands? In other words, she had responsibility just like the dad. She knew that the firearm wasn't secure. She knew it was in a place that was accessible to Ethan. Then, once we find that, the next step is was that grossly negligent? In other words, okay, she knows that the gun is available to him. So now the knowledge of that isn't in and of itself necessarily going to prove that she's guilty of involuntary manslaughter. However, if you couple the fact that he had a mental illness and was having mental problems and was exhibiting signs that he was interested in shooting up a school, now that rises to the level of gross negligence, and she now has a duty of care to him to provide him with mental help to prevent him from doing a school shooting. But in this case, okay, the first step is you have to find that she had the ability, that she was aware that the firearm wasn't secured. And I think that is something that the defense attorney didn't do a good job of helping the jury to understand how they're supposed to deliberate. Because the way I'm hearing this judge's instruction is that if they find that she had, in her belief, the gun was secured and that there was no chance that that gun was out of the house, this case ends right there. It's not guilty. And the father is the one in this case who was responsible for the gun. He was the gun owner. It had been 3 days since that gun had been in her possession, since they had been at the gun range. And the idea is that the gun, that the gun was secured. So again, this is a situation where the father here, if he was on trial, being the gun owner, being the one in the household that was responsible for securing the firearms, he might be in a different situation here, depending on the evidence they have. But the evidence that the state had in this case that she was responsible for the firearms is nil. They can say 3 days before she was at the gun range. But other than that, she turned it back over to the dad. The dad was responsible for securing it. In her eyes and knowledge, the dad had secured it, hidden the firearm. That's even spoken about in the text messages between the two of them. So that just came to mind. I just think that if that is the way the jury, if I'm reading that right, and I believe I am, then in my opinion, I think we have a situation here where the defense attorney should have absolutely done more to explain to the jury how they're supposed to analyze the case. But let's get back and listen here.
For exercising such control. Second, that the defendant knew the facts that gave rise to the duty. Third, that the defendant willfully neglected or refused to perform that duty, and her failure to perform it was grossly negligent to human life. Fourth, that the death of Hannah St. Juliana was directly caused by defendant's failure to perform this duty. That is, that Hannah St. Juliana died as a result of defendant's failure to exercise reasonable care to control her minor child, so as to prevent the minor child from intentionally harming others, or the minor child from intentionally harming others, or the minor child from so conducting himself so as to create an unreasonable risk of bodily harm to others, when the defendant knew that she had the ability to control her minor child and knew of the necessity and opportunity to do so. In count 4, the defendant is charged with the crime of involuntary manslaughter resulting from a failure to perform a legal duty. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, the defendant had a legal duty to Justin Schilling. The legal duty charge here is one imposed by law. In Michigan, a parent has a legal duty to exercise reasonable care to control their minor child so as to prevent their minor child from intentionally harming others or prevent their minor child from conducting themselves in a way that creates an unreasonable risk of bodily harm to others. This duty arises when both of the following are true. A, the parent knows or has reason to know that they have the ability to control their minor child. And B, the parent knows of the necessity and opportunity for exercising such control. Second, that the defendant knew of the facts that gave rise to the duty. Third, that the defendant willfully neglected or refused to perform that duty, and her failure to perform it was grossly negligent to human life. Fourth, that the death of Justin Schilling was directly caused by defendant's failure to perform this duty. That is, that Justin Schilling died as a result of defendant's failure to exercise reasonable care to control her minor child so as to prevent the minor.
Now, the thing that makes me concerned about when you listen to this instruction is the idea that they're going to say that she had a legal duty to essentially be aware that, the way they're trying to apply this is that she had a legal duty to these children, and that essentially, if this is applied, any parent, in other words, your kid goes to school and gets into a fist fight, that you had a legal duty to control your child in school, and that you did not instill a value system in that child to say, we don't hit. And I think that is a huge, huge concern and an overreach, in my opinion, to how a duty of care is supposed to be. Duty of care, in my opinion, duty of care would be your child is sick and your child is sick, or your child, you have a duty of care to your child. If your child, you have a duty of care to ensure that your firearms in your house are secured. And in this case, it would be the child picks it up, is playing with it, it goes off, and he shoots his friend, or he shoots himself. In that case, you have a duty of care to the child for purposes of um, for purposes of making sure that that firearm is secured, and that that firearm is not going to be used in a way that is reckless. However, stretching that duty of care to say, okay, you're supposed to understand that your child makes an adult decision, acknowledged by, hold on. Apologize, my dog's going off at the postman. So, that you're supposed to have a duty of care that extends to this type of a scenario, where the state has acknowledged, by charging him as an adult, that this is a circumstance that rises above the new normal juvenile actions, that this is a young man who doesn't have mental defect. Remember, they didn't allow him to plead guilty by mental defect. They didn't acknowledge his mental defect. They went and sentenced him to life without parole. Okay. And when he had his hearing, okay, which he was entitled to, if the state felt that he had a mental defect and mental problems, that would have been a reason to have given him an opportunity for parole. And the state, in their own case, and again, I believe this should have been allowed to have come in, because the state of Michigan is having their cake and eating it too. They are essentially going and arguing. The same prosecutor, Miss McDonald, the same prosecutor, is sitting in court saying Ethan Crumbley deserves to go to jail for the rest of his life because he intentionally, willfully made an adult decision without any mental defect. He is an evil person, and he did an evil act that deserves for him to be locked up for the rest of his life. They then turn around and charge his parents and say that they're charging the parents because he was a mentally deficient individual. He had mental problems, and they gave him access to a gun. And as a result, they should have known. They should have known that he was having mental problems, that he had, and that because of the mental problems, he should have never been allowed access to that gun. And they could have prevented this by getting him mental help. But the state hasn't, and he's been in their custody. The state hasn't provided him with any mental help. The state didn't have any finding. They didn't send in an expert to come and testify at his hearing and say, listen, we have a young man who was mentally troubled, and we want to help and care about. No, they didn't do anything like that. In fact, they argued the opposite, that there was no mental issue. So how are we going? I mean, again, which makes this case even more egregious with the way they presented it when you consider that fact. And when you listen to the jury instructions, the only way this jury comes to the conclusion is they have to find, number one, that she knew that he had access to the firearm. She made that available. She did nothing to prevent it. And that she also, that he had mental problems and issues, and that she allowed somebody who was depressed and upset with mental problems to the degree that he went and shot up a school, that he then went and accessed a firearm, took it to school. She had knowledge of that was reasonably foreseeable due to his mental illness. But the state denies his mental illness to ask that he be sentenced for the rest of his life in prison. I mean, it's crazy. And the state doesn't just get to go, in my opinion, they don't get to present two sets of facts. You cannot have two separate realities, one that exists for purposes of locking Ethan Crumbley up for the rest of his life, and one that goes and locks up his mother, and have the same prosecutor in the courtroom presenting both theories. An attorney, as we learned in the Tyrone Tucker case, has a obligation to the bar to be honest and to represent the truth to the court. And how do you have a prosecutor sitting in a courtroom representing in one case that Ethan Crumbley doesn't have mental illness, that he was just a kid, just an evil person, the most evil individual, no mental illness, deserves life in prison without the possibility of parole, comes over to mom's trial, sure will be over in dad's trial, and says, boy, poor Ethan Crumbley, he was depressed, he was mentally crazy, and these parents were so neglectful that they missed this. It was so obvious to everyone that was around them. It was so obvious to the reasonable person. Well, apparently, Mr. Prosecutor, it wasn't obvious to you guys, right? As you've had him in your custody, it wasn't obvious in considering his sentence or his punishment. No, it wasn't. Because it wasn't convenient. Because this has been the theme of the prosecution's case, is that anything inconvenient to their case, they've pushed away. Now, why the defense attorney didn't want to argue that, I don't know. I like I said, I've not had access to the pleadings. I can answer that question. But when you listen to these jury instructions and what the jury was instructed on, and you wonder to yourself, how, if you go back and watch his sentencing, and you're going to hear that the state obviously had the ability to say he was insane, he was depressed, he had mental defects. That absolutely would have been mitigating factors that should have allowed him to have the opportunity for parole. Because if you believe that this was a depressed young man who was suffering at the hands of neglectful parents, then he should have had a right, even though he did a horrific act. This was under the state's theory in the case presented against Jennifer Crumbley, this was the ultimate crying out, which you would think would lead to someone, if this is the ultimate act of crying out for help, you would think the state would want to come in and deliver that help and wouldn't want to deny that help. It would want to give him an opportunity to reform himself, because now he's out of the hands of the neglectful, evil parents of Jennifer and James Crumbley. But clearly, that wasn't what they thought when they had Ethan before the court. And clearly, it tells you the credibility of this prosecution and what they're willing to do. And you have to ask yourself, why? Why? Because this should be about facts, and the facts should be consistent against Ethan Crumbley, and they should be consistent against his parents, and they should all tell us a consistent story. There shouldn't be changing. I genuinely think she's not guilty. No one knew what he was going to do. He was saying he saw demons back in March, nowhere near the crime. Correct. And when you listen to her testimony, it makes perfect sense what he was saying he saw, and the fact that these demons were not tied into a mental illness, from the standpoint of the fact that there was a 7-month separation, and that it appears that what he was really talking about was they thought the house was haunted. And he genuinely thought it, and that was a running joke and a running playful thing. And clearly the state agrees, because the state did not present or did not agree that he was that should be considered as a mitigating factor. And they argued that, again, that it was just pure evil intent. He's irreformable. He's irredeemable. And that this had nothing to do with mental defect. It had to do with him just being a bad person. And that, again, his parents, there's nothing to indicate in what the state presented that the parents were aware that they had an individual in their household that was like this. They thought they had a kid who was just maybe a little socially awkward. He was struggling a bit. And the state think they neglected their son because they were spending time at the barn with their horses. Everyone can. Yeah, exactly. Well, the whole thing is the state ended up charging this case way too early, like her attorney said. And now they've been stuck with having to figure out how to proceed because there's a national spotlight and glare. So they didn't want to turn around and say, well, we're going to dismiss this case because they knew that would look horrible. So they did what they do. Again, they moved forward. It's no different than the questions that circulate around Tyrone Tucker down in Florida. Why did they proceed with that case when they realized that it wasn't a good case? Because they had to, because they didn't want to admit they were wrong, because they don't believe that they can effectively enforce our laws or be law enforcement agents if they have to ever say they made a mistake, when that is correct, absolutely incorrect. If you believe a case doesn't work anymore, it's okay to dismiss it. It's okay to say, hey, we made a mistake here. But that's not what they're going to do. And certainly when they stood up in court and held out to the court that Ethan Crumbley was an adult, responsible for his own decisions. Remember, when they try him as an adult, that is a statement that he is responsible for himself and no one else was responsible for him or decisions he made that day. And now, access to a firearm, again, I understand if they could have put that with her, but they can't do that. Do I see them dismissing the case? I don't know. They might. In this case, they might. It depends. Probably they would interview the jury in this case and see what their thoughts were. In other words, if it was like 11-1, they might feel that that was justifiable to dismiss the case. But then again, they may come back and try again, because remember, she's having to pay that attorney that's sitting next to her. So in the state's eyes, if they have to make her try again, she may run out of money. That attorney may say, you know what? I can't go through another trial. I can't afford to do it at an appointed rate. And she may back out and say, sorry, Jennifer Crumbley's going to have to get a new lawyer for the retrial. As far as James goes, I think James is a different set of circumstance because he's a gun owner. So I think that there's going to be a stronger case to say that even if he didn't secure his firearm, so I think they're going to be a little more confident in his case, in the sense that he's the gun owner, he's the guy that was responsible for the firearm being secure. So she's able to offset that to James, and she's able to show, listen, she clearly didn't have a lot of experience with firearms. She knew firearms was a hobby of his. Her hobby was horses, and him and Ethan had a great, father and son hobby, or at least in their eyes. And that's what she thought, never dreaming it was going to lead to where it did. But so I think they're going to go forward with the case against James. If it's a hung jury now, and if it's guilty, of course. Now, if it's not guilty, I think that will give them pause. And I think that, you might, well, yeah, exactly. I mean, and that's the thing too. They did secure them. I mean, I agree with you. I think the evidence is that they secured them. They hid them. Ethan was a child. Again, remember, and this is significant, Ethan was charged as an adult, meaning they believe he was capable of making adult enough decisions to go find the firearms, to go do this on his own, which means, yes, he was able to exhibit the manipulations needed to go in and find and break the rules. Listen, unless you're living under a rock, or maybe you've never been a parent before, but a teenager is a very sneaky individual. You're dealing with a partially developed adult. You're dealing with a more probably dangerous version of an adult, because they don't always see through to their actions. They're not able to see the future in their actions. They're impulsive. They're doing things in an impulsive nature, and they're also doing things with, like I said, a much more developed mind than, say, a 5, 6, or 7-year-old. There is precautions you have to take, but you also have to acknowledge that many, many, many teenagers, regardless of the precautions you put in effect, if they want to go do something, they're going to do it. And that's why I said, in this case, the state is essentially saying, you chose to be a gun owner, and since you were a gun owner, and your kid chose to do this, you were irresponsible for being a gun owner. That is the veiled case they're making. And I believe that's going to fall short in the community that they're making this argument in. Unless they pulled all the jury members from Oxford, but I highly doubt that that they're going to go and I highly doubt that defense attorney completely got outmaneuvered and didn't get people on that jury who were gun friendly or gun owners, in other words, who would be sitting back there in that room understanding what the prosecution's saying here. Because for you to get to the point that for you to accept the prosecution's theory of this case, which is basically Ethan Crumbley, uh, you know, uh, is this mentally deficient individual. The parents were powerless over this. And the fact that they chose to put the gun in their house, even though they secured it, they hid it, they did all the different things. Again, the state wanted to turn the fact that he knew how to shoot a gun against him. In fact, really, that's evidence that says they were responsible. They were responsible enough to teach him how to properly fire the gun. That is something that you would expect and you would want. So that shows they were being responsible and teaching him how to handle the firearm, teaching him how to use the firearm, and they were giving him trust. There's no indication for the 7 months leading up to it that they had any indication that he was in some sort of mental state that he was going to go shoot up a school or harm anybody else. Jennifer Crumbley's belief is, hey, again, father, son, her husband has an interest in firearms like she does in horses. They're going to the shooting range. They're being responsible. They're teaching their kid how to responsibly handle a firearm, shoot a firearm. You go to the shooting range and you do this. They're in a community where this is just common practice. It's so common that at homecoming, the girls are taking photos with guns. So when you look at it inside the context of that, it's not, there was nothing present that would have made them think, oh my God. Now, when she shows up at the school, she sees this sheet. If you look at that sheet, that they claim is this horrible, crazy drawing that should have immediately made them think my son's a school shooter. It doesn't admit that when you look at it. What you see on there, it looks to me, and again, when you're just looking at things and then you have a school counselor there and you have the counselor giving input, it's certain, and you've already got that. Remember the pretext. The counselor concludes, they call her in, she goes in. Had they come in and said, we think your son's going to shoot up the school, I guarantee you she'd have been taking him out, taking him home and locking up all the guns and taking the guns somewhere else and said, oh my God. But no, that's not the pretext. It's come in. Here's what we think is going on, Miss Crumbley and Mr. Crumbley. We think he wants to harm himself. We're worried about him. We want to support him. We want to get him counseling. We're not going to punish him. What do we want to do here? We don't think he should be alone. Do you have, again, not, we want you to take him home. And do you have the ability? No, you don't. Okay, well, here's what we would probably recommend then. If you can't provide an environment where someone's going to be with him at all times, let's let him go back to class. Let's let him be around his friends. Please pursue getting him a counseling appointment. We'll give you 48 hours to do that. If you have problems within 48 with being able to get an appointment, let us know. We're here to help. Ethan has talked to us. He's all about video games and he wants to be a video game designer. He's struggling. And of course, they did know about the grandparent. They did know about the friend. That's why they believed he wanted to harm himself, because he was depressed about these things in his life. So when that's the presentation, if no shooting ever happens, nobody is thinking twice about that. Everyone's thinking, wow, what wonderful school officials who were so helpful and so caring that they stepped up and decided we're not going to punish him. We're not going to punish this kid. Not to mention, they didn't punish the kid because he had no disciplinary jacket. This was not a kid that was reaching out or calling out. That's what makes this so insane. That's why this makes this any kid in America. Okay. Any parent in America could find themselves there, because the thing you have to understand is there was no history here, regardless of how the states tried to present things. There was a history of about 6 text messages from 7 months before. He interacted with his dad. He went to shooting ranges with his dad, something that's as common as hunting is in my area, where lots of kids hunt, and hunting season's a big deal, and it was apparently very common down there. He's having some problems. He's got a friend who's left, who leaves, and that was his friend, and that was very upsetting. He's lost his grandparent a couple of months before, and he lost a family pet. He's dealing with some things. His grades aren't where they want to be, so they're arguing over grades. They're taking away the shooting range. They're parenting. They're trying to give him consequences. They're trying to give him a way back. You hear in the text messages 6, 7 months before, all I care about is he goes to work, he does his schoolwork, and he gets his phone back, and he gets well, at that time I don't think they had a gun range, but he gets his phone back. He gets his video games back. That is the language of a parent that cares, who's trying to figure out a consequence system to help her child, inspire in her child the willingness to be responsible to himself. But little did she know is he didn't want to be responsible to himself. He didn't want any responsibility whatsoever, because it wasn't about a kid. This was about a kid that had made a decision that he wanted to do something secretly. And again, as all science behind this has shown, as the state's own experts shown that they did not said, there is no way you can predict this. When a child decides, or an individual like this decides they're going to do this, the ones that do it. They don't put hit lists out. They don't put crap out on social media, but commonly they just do it. They will write. They will have things prepared so that when the act is done, they will have their explanation, and they will put the stuff out, especially if they're going to kill themselves. But he wasn't planning to kill himself. Obviously, he gave himself right up to the police. Well, and that's, I think that was shocking, but I think that, again, that just demonstrates again how weak the state's case was. They didn't have a case. So they literally had to go. I can't imagine what they're going to say about the dad. I mean, this was a situation where, like I said, I believe these parents fell out of favor with the police the moment they asserted their son's rights in that police station, the moment that they said, we want a lawyer and we want our son to talk to a lawyer. And the police said, you know what? Fine, Mr. and Mrs. Crumbley. We've given you the ability to be on our side, but you want to be against us? No problem. Be against us. And why? Why? Ask yourself. Go back and play the videos of this case. Why? And she couldn't understand it, and James Crumbley couldn't understand it. Why is she the one that ends up in the handcuffs? And she's the one that she was the one who asserted in that meeting, we need a lawyer. James is going to talk. And she immediately said, we need a lawyer. I think we need a lawyer. I don't think we're going to talk. And you saw that detective get upset and start explaining, well, now listen, we have, we really, and then James Crumbley said, well, yeah, I guess we should. And then they talk a little bit more, and then they get into the room, and then James Crumbley's like, he's following the leadership that his wife put out. That to me is the definition of being a vigilant parent. That is a definition of what you should do. Even in a worst case scenario, your kid's done the worst thing imaginable, and you're standing in a police station saying, no, we're getting him a lawyer. We're going to have him talk to a lawyer. We're going to consult with a lawyer, and a lawyer's going to be involved. And guess what? The police didn't like that. So they said, fine. You know what? You want to be against us? We'll show you against us. They go raid their house. They have her in cuffs out in the car. And they basically make it clear, we don't like your attitude. We don't like your approach. And you are going to see the consequences of what it means when you aren't cooperating with the police. And they made a show of power, plain and simple. Anyways, let's finish watching the rest of these instructions.
Minor child from intentionally harming others, or the minor child from so conducting himself so as to create an unreasonable risk of bodily harm to others, when the defendant knew that she had the ability to control her minor child and knew of the necessity and opportunity to do so. There may be more than one cause of death. It's not enough that the defendant's act made it possible for the death to occur. In order to find the deaths of Madison Baldwin, Tate Meir, Hannah St. Juliana, and Justin Schilling were caused by the defendant, we must find beyond a reasonable doubt that the deaths were the natural or necessary result of the defendant's act. You heard the evidence that the defendant's son shot Madison Baldwin, Tate Meir, Hannah St. Juliana, and Justin Schilling. As previously noted, there may be more than one cause of death, and the defendant's acts or inactions need not be the sole cause of harm. In order to find that the death of Madison Baldwin, Tate Meir, Hannah St. Juliana, and Justin Schilling was caused by the defendant, you must also find beyond a reasonable doubt that her son's act of shooting someone was reasonably foreseeable. Gross negligence means more than carelessness. It means willfully disregarding the results to others that might follow from an act or failure to act. In order to find that the defendant was grossly negligent, you must find each of the following three things beyond a reasonable doubt. First, that the defendant knew of the danger to another, that if she knew there was a situation that required her to take ordinary care to avoid injuring someone. Let me read that again. First, the defendant knew of the danger to another, that if she knew there was a situation that required her to take ordinary care to avoid injuring another. Second, that the defendant could have avoided injuring another by using ordinary care. Third, that the defendant failed to use ordinary care to prevent injuring another when, to a reasonable person, it must have been apparent that the result was likely to be serious injury. I think I've told you this before. I'm not sure we did the greatest job at this, but I previously ordered the parties to be precluded from using the shooter's name during the trial. When you go to the jury room, you'll be provided with written instructions of the final jury. You'll be provided with a written copy of the final jury instructions, and you should first choose a foreperson. The foreperson should see to it that your discussions are carried on in a business-like way, and that everyone has a fair chance to be heard. During your deliberations, please turn off your cell phones or other communications equipment until we recess. A verdict in a criminal case must be unanimous. In order to return a verdict, it's necessary that each of you agrees on that verdict. In the jury room, you will discuss the case amongst yourselves, but ultimately, each of you will have to make up your own mind. Any verdict must represent the individual considered judgment of each juror. It's your duty as jurors to talk to each other and make every reasonable effort to reach agreement. Express your opinions and the reasons for them, but keep an open mind as you listen to your fellow jurors. Rethink your opinions and do not hesitate to change your mind if you decide you were wrong. Try your best to work out your differences. However, although you should try to reach agreement, none of you should give up your honest opinion about the case just because other jurors disagree with you or just for the sake of reaching a verdict. In the end, your vote must be your own, and you must vote honestly and in good conscience. If you have any questions about this jury instructions before you begin deliberations or questions about the instructions that arise during deliberations, you may submit them in writing in a sealed envelope to my clerk. Possible penalties should not influence your decision. If the defendant is found guilty, it's my duty to fix the penalty within the limits provided by law. If you want to communicate with me while you're in the jury room, please have your foreperson write a note and give it to the clerk. It's not proper for you to talk directly to me, the lawyers, the court officers, or any other people involved in the case. As you discuss the case, you must not let anyone, even me, know how your voting stands. Therefore, until you return with a unanimous verdict, do not reveal this to anyone outside the jury room. When you go to the jury room to deliberate, you may take your notes and full instructions. I believe that the defense exhibits are hard copy, and the prosecutor has their exhibits on a thumb drive. We have a computer that we're going to set up in the jury room, and you can look at those exhibits. If you want anything else, you can let us know. I think it's a thumb drive, right?
It's a portable USB or hard drive.
And Your Honor, I just want to make sure that mine are in a binder. I left it for Ashley.
Okay. Yeah, we're going to send all the exhibits in right away. All right. Did we give it a written copy? I think I told you this earlier, we can replay a witness. That's very possible. And I think I told you this in the beginning of the trial. You can't, however, fast forward to the spot where you have a question and I'll yell, aha. You have to hear the whole witness, direct, cross, redirect. It's the only way that's fair to both sides, but it is possible to replay testimony, all right? The defendant is charged with 4 counts of involuntary manslaughter. These are separate counts, and the prosecutor is charging that the defendant committed all of them. You must consider each count separately and all of the evidence in the case. You may find the defendant guilty of all or any one of these counts or not guilty. I have a verdict form here. It's like a flow chart. There's questions. Number 1, involuntary manslaughter as to Madison Baldwin. You can check not guilty or guilty of involuntary manslaughter as to Madison Baldwin. Count 2, involuntary manslaughter as to Tate Muir. Not guilty, guilty of involuntary manslaughter as to Tate Muir. Count 3, involuntary manslaughter as to Hannah St. Juliana. You can find the defendant not guilty or guilty of involuntary manslaughter as to Hannah St. Juliana. Count 4, involuntary manslaughter as to Justin Schilling. You may find the defendant not guilty or guilty of involuntary manslaughter as to Justin Schilling. So, I'm amazed that we maintained 5 alternates. It's, a credit to how great you were at being here in time and following the instructions, and we're so appreciative. So, we're going to choose 5 alternates, but I'm still going to sequester you. All right. I'm gonna have you kind of cooling your heels and being bored in Judge Anderson's jury room. If deliberations went beyond today, I might consult with the lawyers about dismissing some or all of you. I think you can imagine that this has been a very emotional and stressful event for both parties, the prosecutor, the defense, and the families, and it's been a lot for the courthouse too. So you all look really healthy, but life happens. So I am going to sequester 5 of you. When I pick your names, my clerk is going to take you to Judge Anderson's jury room. You've all ordered lunch, so we'll match up the numbers and you'll get your lunch in a while. I know you're going to be kind of bored stiff for a while, but we just want to be sure that we can conclude this trial. Then the other 12 of you will go into my jury room and start deliberating. I should also say the 5 of you that are sequestered still cannot discuss the case or do research or Google it or look at newspapers or go on Facebook. So you're still sequestered as if you're home. All right. Sometimes I would, I thought about sending you home, but I'm gonna keep you for a little while. But you're still sequestered. Can't look at any media or talk to anyone about the case, and can't discuss the case amongst you 5. The 12 of you can start deliberating momentarily. I'm going to consult with the lawyers to make sure that there aren't any errors in the jury instructions. Bring in the exhibits, and then you can start deliberating. It's important that you only deliberate when you're all there. If one of you steps out for some reason, you shouldn't be deliberating. And you can send us notes about when you want to take a break. I still would like you not to go to the cafeteria, please. And be careful if you're walking through the courthouse, please. There's obviously a lot of interest in the case, as you know, and we've gotten this far. So, in any event, I'm going to choose 5 of you randomly, and those 5 of you will go to Judge Anderson's jury room. Right. Juror in seat 15. You're seat 15. Juror in seat 17. Juror in seat 10. Are you 10? Seat 10? You're in seat 10. Juror in seat 4. In seat 4. And juror in seat 9. All right. So 17, 15, 9, 10, and 4. I'm sorry they could probably be bored. We'll get back with you as soon as possible, all right? I did bring some cookies, and there's candy, and there's muffins, and what else? Licorice, oranges, apples. So, right. So if you could, I'm trying to think of it, might be best to come this way. There's, can you go both ways? I know it's so crowded. It's the coziest my three box is ever. So I'm gonna ask the alternates who I chose to go to Judge Peterson's jury. Right? We'll bring you coffee too. So I'm going to ask you to go to the jury room. Give me a moment. I want to consult with the lawyers and make sure that there are no errors in the jury instructions. I'm then going to send in all the exhibits and copies of the jury instructions for you. All right? And if you all decide you're going to leave and walk around or what, whatever you're going to do, just let us know. We will all be awaiting you. Okay? All right.
All rise for the jury.
No, it does nothing, people.
Nothing from the defense.
We're going to send in the jury instructions, and you're giving us.
Yeah, first report.
Yeah. That computer can handle that, right? You're not giving us any hard copy.
Correct.
Right, yeah. Okay, and we have your exhibits. Please make sure we have phone numbers for you, because, we get that usual question, can we have copies of the police report, all the questions that usually come out of there, so.
Judge, there are 5 exhibits that we didn't include in the USB to the jurors. That's the shooting video,
Okay.
the photograph with the blood from the bathroom,
Okay.
crime scene photo depicting the 2 victims, the video that was played with Gibson Marshall, and the video that was played with Molly Darnell.
Okay, do you want me to somehow tell them that?
I
Maybe
think
bring
they
that
should.
up.
They should be made aware of that, Judge.
Oh, okay, well, I would have told them that before we went in. Can you write those things? Do you want me to just tell them?
That's fine. I can write a note on the envelope.
Okay. Or we can give you a, maybe right up there, no, just if you can initial it and just initial it. Okay. What else? Please just be sure that we can find you, because sometimes there's questions.
I'm gonna be right here.
How many
We're close by.
sets of instructions are we sending? You could send 12 sets of instructions. Is that it? Maybe I'll throw them.
Yes. Those are, yeah, and then I gave you the binder, so use the binder.
Oh.
Yeah, the binder just has it like in pages, or page covers. Thank you. You have my cell phone? Yeah, okay.
I hope everybody here would be careful not to have any interaction with any of the jurors.
Yeah.
I think some members of the media have asked that the jury instructions be emailed to them, and I agreed that I would do that as soon as I had read them to the juries.
All right, guys. So it looks like they're dispensing with some formalities in the courtroom here. So
Signature, okay, got it.
I think we're going to skip ahead to live and see if there's any actions or activities. Looks like there's not. So here we are. We're in deliberations now. So obviously, at this point, there's nothing to watch. I'm going to leave this up. My stream will run my software. I have to update the stream every 6 hours, so we should be able to run this. I guess we've been going an hour and 20 minutes, so I've got about 4 hours and 40 minutes more. So I guess about 4:55 o'clock. So if we don't have a verdict by then, we may have an idea of whether or not there's going to be extended deliberations or not into the evening, or they would have the jury go home. Looks like the poll right now, if you're curious, if you're wondering, we have a poll going right now, unanimously here. We've got 14 votes in, 64% not guilty, 14% hung jury, and 21% guilty. So what I've found is when you see cases where you see an overwhelming leaning towards not guilty, that's indicative of reasonable doubt and indicative of the fact that you're going to hopefully see that follow over into the jury room. I was over checking out various different outlets that have polls going on as well. One particular major outlet that had thousands of people in their chat, it is back at almost 50-50. And we saw that in the Tyrone Tucker case, and it ended up in a hung jury. So I think that this case is trending towards the same outcome. I think there's going to be a lot of people out here that are going to, and I think that's going to translate into the, go into the jury room, where you're going to see there's going to be a struggle here for people to see the state's case the way the state presented it, and to see the idea that the information and the evidence that was put forth, that it would show that Jennifer Crumbley was this irresponsible parent who would have, I mean, again, and this is what they have to, this is what the jury has to accept, that she was at such a level of negligence that she would have thought her son was about to shoot up a school and did nothing. And the woman you saw testify, the evidence that was presented throughout this case, I do not understand how 12 jurors could come to that conclusion. I just don't. The only way you walk to that conclusion is if you get emotional, is if you react emotionally to the videos that the state put up of the shooting, to the witness statements from the people that one of the teachers that got shot, the other ones that witnessed kids get shot, the police officers that witnessed the carnage. But you've got to remember, and I hope they remember, this state, the same state that's standing before them and saying, hold the Crumbleys accountable because Ethan was a child and they had a duty of care, is the same state that not but 6 months ago was standing in court saying Ethan Crumbley is not a child. He is an adult. He is responsible for his decisions. He is criminally culpable, and he alone is responsible for this. There's no mitigation. Mental health is not a mitigation in this case. He's just an evil person, so evil to the fact that he was so evil. Their argument is that he was so evil that he superseded the science that indicates that the developing brain of a child doesn't develop fully until 25, that his ability to rationalize, reason, and see the consequences of his actions were not present because of his age, because of his brain not having developed appropriately. But that they said, nope, he is a case that defies all of that. He's an outlier to all of that, to all the science. And he's so evil that he's an adult, that he should be treated as an adult, and he should be sentenced to life without prison, and that there is no redeemable qualities. And then they turn around and they say, well, Not anymore. We don't believe that anymore. In fact, we believe that if Jennifer Crumbley would have figured this out, she could have redeemed him. She could have made him better. She could have got him help, and she could have stopped the shooting. So how do you have that theory? Because, in this case, which requires that to be the case in order for them to say that the access that he had to the firearm, which is a very tenuous link, that she had any control over that firearm. But let's just say that the jury accepts that. So now Jennifer Crumbley could have gotten him help that would have changed that outcome. Well, if that was the case, then he should have been given life with parole. And the state should have been standing there, joining his defense attorneys, imploring the judge that this was a troubled young man with neglectful parents who who could have gotten help. He wasn't provided the help. He's now in custody of the state, and now we can get him the help that he needs, and he can redeem himself and maybe have a life out there. No, that's not what they argued. They argued the opposite, that he was irredeemable, that regardless of the parents' neglect, that wasn't something that made a difference here, and that his defects as a person had nothing to do with mental illness. They had everything to do with being an evil individual, so evil to the fact that he circumvents and defies all the science and everything, all the science that would be presented regarding the mental development of a 15-year-old child. Lock him away, throw away the key, no parole. That's our position. How does the state justify that? And how do we, watching this, within weeks of each other, state of Florida prosecuting a case against Tyrone Tucker should never be prosecuted. State of Michigan prosecutes two different theories of the case. In fact, two conflicting theories. And in my opinion, when there's a conflict of evidence and the state's assertions, especially since it's the same prosecutors, it's not two separate prosecutors. Miss McDonald was present in both of those cases. Go back and watch the sentencing hearing of Ethan Crumbley. You'll see her sitting there just like you see her sitting here in this trial. Isn't there an obligation that you present as members of the bar, as honest members of the bar, that you present an honest case with an honest facts? How do you argue one set of facts and then come over here in this trial and argue a second set? And then just say, oh, it's okay. And the way you do that, the answer is in the fact that they began their case with the inflammatory testimony, the videos of the shooting, and as the defense attorney Shannon Smith said very, very nicely, they didn't have a case, so they came to you with emotion. They wanted you to hate Miss Crumbley. They wanted you to see her as a cheating wife. They want you to see her as this cheating, evil person. They want you to hate her so that when you get back to that jury room, you just hate her. And you see what her son did, and you just lose it. It's like the Salem witch trials. Burn her at the stake. Lose any sense of reason. Forget about the evidence. Forget about the law. Hang her. Send her to prison. Make her pay. It's not how our justice system works. And that's what Shannon Smith said in her closing, which is absolutely a fantastic point. The nice part is the state of Michigan doesn't just get to do this to somebody because they didn't like her attitude when she talked to the police, because they didn't like the fact that she asserted her son's rights. They don't get to do this, not without going through 12 people. 12 people in a community who lives with guns, who lives responsibly with guns, and who absolutely does not believe that any household that has guns in it is any more likely to have a school shooter, besides the fact that a gun is present and there might be access to guns, but that the child in that household is no more predilected to being a school shooter than one who lives in a household without guns. And the bottom line is, even if you have a child that lives in a house without guns, if they want to get a hold of something, if they want to figure it out, if they want to plan this, as the science has said, as the state's own experts said, who never made it into trial, it will happen. And it would have happened in this case. And that's just a fact. And the fact that the state acknowledged how manipulative this young man was and what a predator he was, and that he essentially preyed on his parents to gain access to the firearms. That's how this should have been viewed. He put his focus, when you look at that diary, he says, I have decided on this. I've made sure I have access. I've manipulated my parents. Listen, think of how many kids. I mean, I, as a father of three boys, my kids have absolutely manipulated their way through things. That some I've found out about, some I probably haven't. But it's part of raising children, that you're going to understand that children can be manipulative, especially teenagers when they want to get their way. Now, you hope, and what really should be happening here, and what the state should have truly been interested in, is how do you have, and this is what robs this case of being asked in this way, is how do you have a child with no history of problems, no history of disciplinary issues, seemingly, maybe has a little bit of social anxiety in school, isn't necessarily the most popular kid. How does this kid turn into a gun-toting school shooter committing a mass killing in his school? How does that happen? And that's what we should have been interested in learning, and that's what the police should have been eventually moving towards, and we should have been trying to figure out how to help him figure out, what was the root cause of this. And certainly not manufacturing a case, in a sense, like they have here, of emotion and misinterpreting evidence and stretching evidence and doing things that indicate that the state had no case, because they only do those things when they don't have a case. Plain and simple. Anyways, guys, I'm going to continue to monitor this. I would encourage you to, be in the chat. Leave your thoughts if you're coming in. Leave your thoughts in the chat. Deliberate in the chat. Put your verdict in the poll. I see people moving around, but I think it's just people moving around in the courtroom. Heck, they might even be having proceedings. Sometimes they do that. I know they did that in the Tyrone Tucker case. But a lot of these judges have other cases and things, so they will do things that they, have hearings and have proceedings while the jury is deliberating, knowing that if the jury indicates that they have a verdict or a question, they're just clear the courtroom, bring the jury in, and deal with it. But we're going to leave this up, and that way, if I do happen to be away from the studio, we'll be able to have the verdict run if it comes for some reason I'm out of pocket. And then, of course, once we have a verdict or an outcome, we'll wrap it up. We'll talk about it. We'll discuss it and discuss whether the jury got it right. I think, obviously, I've made my position clear. Make yours clear in the comments. Let me know what you think. Let me know why you think it. Hold on a second. Wait a minute. We got activity. Uh-oh. We might have a verdict. I don't know. Go check some sources out here. Hold on and see if there's any reports. All right, so I'm looking. It appears that the jury has a question. So great timing, because I was about to step away. So it looks like the jury has a question. There's not a verdict here. I just went in and looked. apparently that's the reports coming out of Law and Crime, is that it's a question. I go over there and check. They're normally pretty up on it. So it looks like, I guess they got to get Jennifer Crumbley back up into the courtroom. This will be interesting. Whether or not this question is going to say, "Hey, we're already deadlocked." Can you imagine that? Although I could see that happening in a case like this. Or B, again, as I said, I believe the jury instructions were a bit confusing, and I think maybe they're going to get some clarification on the jury instructions. But I want you to look, right? This is a great thing to look at. Look at the defense table. One woman over on the defense table. Look at the state. 3 prosecutors, multiple investigators. That's what the defendant is up against. Now, Miss Crumbley in this case was able to afford, I guess, through her parents or maybe through selling their house, I don't know, but she was able to afford Miss Smith's services. But look at the firepower that the state brings in. And when you think about the fact each one of those is being paid a salary, each one of those attorneys, each one of those investigators, and you figure most criminal cases are probably ranging maybe $5,000 to $15,000 and to pay the attorney, and then you figure that goes up against, probably in this case was hundreds of thousands of dollars was expended on this investigation. So here we are, guys. It looks like we're live. It looks like they're coming. Judge is going to be coming back in. Well, it appears there's a jury question. From what I understand from my sources that I've tapped into, the jury deliberations have stopped, but what's coming out right now is that there was a question that we're waiting now to have Miss Crumbley brought back into the courtroom. When she gets in the courtroom, we're going to find out what that question was, or maybe there's a verdict. But all indications that I'm seeing right now are that there was a question in the court. Jury has a question. Yep. I assume they're going to bring Miss Crumbley in. I would imagine they have to, because she should be present. She has a right to be present for everything that's going on. But I think we're waiting for her to get brought up, because they have to bring her up from the holding cells. And then I guess the judge probably is aware of the question maybe, and is considering how she wants to handle the question, depending on what the attorneys decide. Maybe it's a simple question. My thought is it's going to have to do with, in regards to the jury's instructions. And I think it was particularly confusing when the judge starts out saying, well, you're here to decide, did she store the firearm? Because it sounded like at the beginning of the instructions that they were making it sound like, well, if you believe she was responsible for not securing the firearm in the house, that was enough. But that isn't how it works, right? You have to, and again, maybe we're here just directly addressed, but the way I heard the instructions, and I would interpret the instructions, is, and having heard jury instructions before in my lifetime, I believe that the correct way that the jury would be coming to a verdict here is, the first thing is you have to believe that the firearm wasn't secured properly. In other words, or that she had some responsibility for providing him with that firearm. So if they believe that that firearm was in the care, control of the father, and that she had nothing to do with that, and they believe that or at least that wasn't established beyond a reasonable doubt that she had anything to do with him having access to the firearm, deliberations stop right there. It's not guilty. You don't go any further. Now, once you move past the idea that says, yes, we believe, and if you read the opinion that was put out by the appeals court, when they get to the issue of foreseeability, they basically say, we're going to hold that those facts are provable, that it is not contested, although it will be contested. But for purposes of our consideration here, we're not worried about the evidence. We're going to assume that evidence exists to the standard needed at that moment, which was that there was a probable cause existed that she had was a part of, or had knowledge, or had the ability to keep that firearm safe and to keep it secure and away from him. So once they find that, now they got to move into, okay, was it foreseeable? In other words, he knows he has access to this firearm, which in and of itself is not necessarily negligent, because if they're teaching him gun responsibility and he knows where the gun is in the house and he knows how to access it, and he's a normal individual who understands gun safety and has, then you would not believe that there would be any reason to keep that firearm from him. So that in of itself would not have been criminal. But in this case, the state's saying, okay, she knew he had access to a firearm and she knew he had mental problems. That was negligent. That was so negligent that it rises to the level of gross negligence, and that her duty of care was to ensure that her mentally deficient son shouldn't have had access to a firearm, which resulted in her failing in her duty of care to the victims in this case, which was to keep them safe from her son. Anyways, let's see what this question is. So it looks like she's back in the courtroom. But, when we talk through this and you talk through the order of deliberations, I think, to me, it's just every time I go through it in my brain, it's like immediately as I'm going through what they have to prove. And again, I wish the defense attorney, I think she did a good job talking about things, but I think she was emotionally involved in this case. She definitely spent some time defending herself, but I feel like she didn't do a good enough job at clearly walking the jury through the process they needed to get to a conviction, which is a really high road in this case. Let's see what the jury has to say.
Your Honor, calling People versus Jennifer Crumbley, case number 222799990, FH.
Karen McDonald on behalf of the people.
Thank you, Marquise, on behalf of the people.
Thank you. I'm Shannon Smith on behalf of Jennifer Crumbley.
Good morning. We got a question. You can be seated. We got a question from the jury that I thought was really easy to answer. I guess I don't know if there's an agreement about that, but if you don't agree, then we're going to decide on the record how to answer it. The question is whether the standard jury instruction 16.10 and 16.13 are different. But it says the 16.10 and 16.13 two different ways that we can conclude that involuntary manslaughter, or a 16.13 a support to 16.10. So I guess I would say the answer to the first question, isn't it? Yes.
It is, Judge, and I would just ask that the court reread 20.30A, which clearly articulates that. So I think that's why it wasn't just a yes or no response, because I think this instruction, 20.30A, is right on point to the question.
Okay, so can I answer the first question, yes?
Yes, Judge.
And then say, please refer to 20.30A unanimity.
Yes, Judge.
Your Honor, I'm not sure. I'm trying to find 20.30A.
It's right between 16.13 and 16.10. It's the one that talks about alternative theories.
Okay, we'll just set there.
It's a non-standard because it's adapted from a civil jury instruction.
I'm sorry,
20.30A, it's a non-standard jury instruction, both sides agree to it. It's a unanimity instruction.
It's regarding one of the jury instructions. I'm trying to figure it out here. According to the judge, she said it's in regards to the alternate theory instruction. And she said the judge feels it's pretty standard and easy to answer, so we'll see how this goes. The defense attorney is trying to find the instruction right now to go over it.
Okay, I believe the court is correct. However, the way I read the question is that the jury is confused, obviously, about there being two ways to prove the charge. When they ask about one instruction supporting another, I believe that they should reread 20.30A, and then the one theory of the prosecution is 16.13, which describes the legal duty. I believe the second theory by the prosecution is 16.10, which describes the theory. Okay, but I think what supports 16.10 is the definition in 16.18. So when this jury is asking for a question about support, I believe the confusion lies in the fact that
They didn't ask me that.
well, when they say, I don't see how 20.3A clears up the question they're asking. I believe the jury needs to be instructed to read 20.3A, and then they need to consider 16.13 or 16.10, and in doing 16.10, understand the definition of gross negligence is in 16.18. That's what the defense believes.
They didn't ask that, Judge, and it's not up to us to guess what they're thinking or not. The answer to the question, the first question is clearly yes, and 20.30A is clearly on point, so.
Yeah, the answer is yes. And then I'm going to say, please refer to 20.30A. Write unanimity. And I'm also going to say, please consider all instructions as a whole.
Thank you, Judge.
All right, I'm going to sign this note in. All right.
Thank you, Judge.
Thank you.
All right.
Point 13 are different. I don't know if there's an agreement about that.
Thank you. I'm Shannon Smith on behalf of Jennifer Crumbley.
Good morning. We got a question. You didn't see it. We got a question from the jury that I thought was fairly easy to answer. I guess I don't know if there's an agreement about that, but if you don't agree, then we're going to decide on the record how to answer it. The question is whether the standard jury instruction 16.10 and 16.12 are different. But it says the 16.10 and 16.13, two different ways that we can conclude that involuntary manslaughter, or a 16.13 a support to 16.2. So I guess I would say the answer to the first question is that.
It is, Judge, and I would just ask that the court reread 20.30A, which clearly articulates that. So I think that's why it wasn't just a yes or no response, because I think this instruction, 20.30A, is right on point to the question.
Okay, so can I answer the first question, yes?
Yes, Judge.
And then say, please please refer to 20.30A unanimity.
Yes, Judge.
Your Honor, I'm not sure. I'm trying to find 20.30A.
It's right between 16.13 and 16.
All right. So my read of that question, it appears, again, going back and listening to it, and again, we don't have the jury instructions in front of us, but what I read in that question is again, there's confusion. What they were asking is if you go back and go back to the jury instructions, what they're confused about is the judge charged the jury that there is two ways they can come to this verdict. One is the theory of the case being that she didn't take action to provide the fire. In other words, she didn't, that she, and again, this is how James Crumbley could potentially be convicted, is that she didn't take action to secure the firearm. And as a result, he got a hold of the firearm, him being a child, she as a parent had an obligation and duty to secure that firearm, and that it would have been potentially likely that him handling a firearm could have resulted in the death of children. So again, for that to be true, she had to have had the responsibility and the ability to have been aware that that firearm wasn't secure. In other words, it's laying out on the kitchen table, it's somewhere in his possession, maybe it's being kept in his bedroom, and that it would be reasonably foreseeable that, yes, a child, a minor, an underage person possessing a firearm could very likely result in the death of someone else by either accident or intentional act or however you want to see it. And in that case, they say, yes, she could be considered guilty of manslaughter. The second act would be the second way or theory of the case is that she knew that he had access to firearms, that she, and again, this is predicated upon her coming into the school, having seen that math worksheet, that she knew he had to access the firearms. She knew there was a potential for access to firearms, and she knew that existed. And as a result, based on the totality of all the circumstances, the text messages from 7 months before, the fact that his friend had left the area, etc., totality of all these circumstances, that she's standing in there, that when she saw the drawing of a dead person on the math sheet, the new weapon that had just been purchased, that she should have been fully aware that, yeah, my son is about to do a school shooting, and that she should have foresaw that. She should have taken him out of the school. She should have, essentially stopped him from going back into the school, because she should have known at that moment that it was foreseeable that he would have done a school shooting. Now, it's also, there's also a component to the negligence factor that if her son was trained in again, the first one, you have to understand, the first theory of the case is going to be predicated upon her irresponsibly securing the firearm. And again, an affirmative defense to that, and again, there hasn't been any evidence, and there wasn't evidence presented that she had any knowledge that that firearm wasn't secured. In fact, what her testimony was, what the text messages show, is that her husband had taken possession of the firearm and secured it. And now, the significance of the video that was played of the night before the shooting showed that Ethan Crumbley, and then I guess what he also wrote in his journal, is that he says, I have access to the firearm, I have access to bullets, I'm committed to doing this. So the question is, did that access come through Jennifer Crumbley? And did she have any ability to stop access to that firearm, or was she even responsible for stopping access to that firearm? In my opinion, the issue at hand with that first theory of the case is she wasn't the gun owner, and she wasn't responsible for storing that firearm. And there was no evidence presented that Jennifer Crumbley was aware and ignored the fact that that firearm was in his possession. And the fact that the firearm case was in the bedroom of the Crumbleys, where James Crumbley had gone home, opened it, and realized it was gone. Not to mention that Jennifer Crumbley left the house earlier, not after, but earlier. She left and headed to work before James and Ethan left. So she was already out of the house. So bottom line is, I believe, if my memory serves me correct. So bottom line is, she, as far as responsibility for the firearm, she really did. The case wasn't strong there. But what I think the question was really being asked there, and I think the defense attorney heard it correctly, is key to the fact that they were saying, is number one, in other words, do we have to find number one exists in order to find, in order for, like, in other words, is number one supporting, is it required that for us to find her guilty under the theory of that it was reasonably foreseeable and she should have done something? Do we need to find that she had access and was responsible for securing the firearm? That was the question I think they were asking, because what I think is that there must be someone back there who's saying, it's either one or two things. And you may be right, Eon, that in fact, there's probably someone back there saying either A, she knew where that firearm was, and she knew that there was access to the firearm, and as a result, um, uh, or she's saying, I don't believe she had access to the firearm. So even if you think that it was foreseeable, it doesn't matter. If we don't believe she had access to the firearm because the husband was the one that was responsible, we got to find her not guilty. And I think that was probably some of the debate, that somebody, there are some not guilties back there for certain. And I think this was someone back there saying, no, you're wrong on that. That it's and or. One theory says, yes, she had to have knowledge of where the firearm was. Another theory says didn't necessarily have to have the firearm secured. It's not required as part of that. She just had to know that he could have had access to the firearm. And as a result, when she saw what she saw at the school, she was neglectful in the fact that she just didn't take her kid out of school and dig deeper. She leaves him at school. Turns out he's got a gun in his book bag. And man, this could have been prevented if she would have just taken him out of school. The very simplistic thought process in that, to get there. But I just find that, to me, if that's going to be, if they're going to rule that out, I think what we're going to see happen is I think the jury's going to move away from the idea that says, okay, we've got a situation where we're going to hold her accountable for the firearm. That's going to be moved out. Now they're going to get into the debate of, do we think it was foreseeable? And of course, what's going to come in. So I don't necessarily think this means anybody's leaning towards guilt. I think they're trying to figure out how to move through this deliberation and whether or not they would say, well, if somebody says, I don't think she had access to the firearm, is that enough just to go not guilty on everything? And I think that's what they were looking at. My read is, yes, it would, because if you believe that she had nothing to do with the firearm being secured, and she didn't have any belief that he could have had any access to a firearm, then that directly speaks to the reason, to the foreseeability issue, because she couldn't have then foresaw that he would have done a school shooting if she didn't think that he would have had access to the firearm because dad had it locked up and secured. So in her mind, school shootings not foreseeable at all and under any circumstances because her husband had the gun locked up. Again, when you get to dad, it's a different situation because he's the one that was responsible for locking it up. So if the state can show that he didn't secure it, then in his mind, the individual that should have been raising red flags when they left the school is, oh my God, my firearm isn't locked up. And the fact that he went in and powered DoorDash up and went dashing instead of going home to check on the firearm, because he's the one that's responsible for the firearm. Now we could say that he could have reasonably and foreseeably thought, well, damn, my son's drawing pictures of guns, talking about hurting himself. I better go home and make sure that gun is okay, because what if he has the gun with him in school just to shoot himself? So at that point, the father would have been the one that could have said, he could have potentially foresaw that he was hurting himself. He could have potentially foresaw that he was doing these things. And, in my opinion, that is, that's great evidence against the dad, not the mom necessarily. Give me a moment here. You just said that my live might have been ending here. I don't know if it did. Looks like it did. Why did that happen? Okay, no, I'm still up. I don't know. Came up and said that it was going to end. The live stream was going to end. I don't know why I was saying that, but I'm still live, I believe. Tell me if you're watching. Put a comment in if I'm still up. Hopefully I am. I don't know why it came up and said that. But anyways, point is that I believe, yes, when you're, again, and this is why it would have been much better, I think, and much more helpful to this jury if the defense would have maybe gotten into more of talking about how to deliberate this case, so, as some defense attorneys will do, and say, listen, this is how we do it. Okay, good. Thank you very much, Jan. Because to me, that is a that would have been that's an important factor here, because I think this jury is confused. And I mean, even myself, when I'm listening to jury instructions, I'm like, this is incredibly confusing. Most of the time the jury instructions will give a little more guidance, but it's incredibly confusing having these two ways. And if the state wants it that way, because the state wants the jury to get confused back there and think, well, it's got to be done this way, or if I find this, then I have to find this. And it's the defense attorney, in my opinion, as much as I think she hit some very good points about the weakness of the state's case, I think it got I think she got caught up maybe in defending herself and some of the criticisms that were out there, which really didn't matter and wouldn't matter if her client gets acquitted. How long do I think she'll get? Well, she's facing up to 15 years on each count. I would be inclined to believe that they're going to throw the book at her if she gets convicted, because I think so what I would say, by throw the book, I don't think she'll get 75 years. I think she'll get probably 30 years is what I would say. I think that they'll run two concurrent. She'll get 15, 15, 15. She'll get 15 on all. They'll run two concurrent, and she'll get 30. And then I'm not sure how good time works in Michigan. I'm thinking it's probably maybe 2/3 or something. So that would mean that she would serve about 20 years. But that's what I would think, because again, if this jury finds that she, the state's going to probably ask for the max, but I think that the judge here who sat through this case, I could tell, I think the judge is a mom. The judge doesn't seem like an unreasonable person. I think she's going to come somewhere in the middle there, understanding that this lady also has lost a tremendous amount in this, but yeah, that's, well, if you're from England, then the way it will work over here is she will get this offense is punishable by up to 15 years in prison on each. She's charged with 4 counts. So she now normally, like if it would be 4 counts that aren't derived from the same act, you could make a case that would say it would all run concurrent. In other words, there might be 4 15-year sentences on the table, but commonly they will issue, 4 15-year sentences, but it would be served concurrently. In other words, you would get credit. You'd get credit for serving one sentence, and it would that credit would extend into all of the other sentences. However, in this case, because of the fact that yes, it was part of a mass shooting, but each individual shooting is its own deal. So he shoots one person, he shoots another person. It was not the same bullet wasn't used. Each one was an individual act. So she's responsible for each individual act. So there's going to be some idea that the state would make the argument that you would be discrediting one person's death by allowing her to serve the time on another person's death. And since she forced the trial and didn't take a plea bargain, in fact, that would have been a potential negotiating tactic in the plea bargain, which would have said, hey, avoid trial and we're agreed to a 15-year sentence where you're going to get 4 15-year sentences, but we're going to let you serve one sentence. And then she would have gotten, probably done a third of that. I don't know if that was ever on the table, but that would have been one way that the state might have been open to negotiating with her if she'd agreed to lay down and plead guilty and not force them into a trial. The fact she forced them into a trial, a lot of times, that means that they're going to go and go for the max. Now, I just think this judge is going to look at the totality of the situation and maybe moved to find somewhere in the middle. Now, again, I don't have any information as to this judge's sentencing patterns or how she is as a sentencer. I mean, some judges come across like she does, and she's very fair and very nice in the courtroom. And then, you get the conviction, and then she just lowers the boom. But she could potentially get up to 75 years if they sentence her consecutively, which 75 years would mean she would do potentially about 2/3 of 75 years. So she'd be doing about 60 years in prison. I think, well, somewhere around 60 years in prison, which is pretty much a life sentence for her. So the potential here is that she could spend the rest of her life in prison. I would believe the state would be absolutely all about that, because that's what their goal here is. They want vengeance for these kids, and they want to lock her up for a long, long time. So this jury, um, you know, has a big responsibility back there on whether or not they want to lock her up, and whether they really truly believe that she acted and believed and had knowledge that she thought that, hey, my son is imminently going to shoot up a school. I'm going to ignore it, and we're going to move forward with it. So anyways, we're going to, that's where we stand. But I will be back. I'm going to step out for a minute here and go mobile. And I'll be in the chat watching. I've got to go do a few errands. I'm going to leave this up. Hopefully my broadcast stays up. Like I said, I don't know why I got that message that it was ending. But continue to make your verdict known in the poll here. I'm curious to see. We're still at 53% not guilty, 12% hung jury, 35% guilty. So that speaks volumes, in my opinion, from the standpoint of when you have a majority of people that are leaning towards not guilty or a hung jury, that speaks volumes and speaks well of the potential here for a not guilty verdict. Most cases I've seen. Let's see what Law and Crime's up to right now. I'll go over here and check that out. Let's see if they've got. So they're at 53% guilty, 28% not guilty, and 19% hung jury. So they're at 47% essentially either not guilty or hung jury. They're running about 50%. Same thing that happened with Tyrone Tucker case, and we ended up in a hung jury situation. There was a shooting case that I covered, one of my first cases I ever covered on this channel. So a lady that, or not shooting case, it was a car situation where a lady ran over her husband. And that case, same scenario, about 50%. She was found not guilty. So I think we got a strong opportunity here for not guilty. But I will be back as soon as there's any type of verdict. If I'm out during the verdict, I'll be watching in the chat, and of course I'll come back in studio and we'll talk about the verdict as soon as one comes down. We'll see how this goes. So I will talk to you guys in a little bit here.
cameras in here, aren't they?
Yeah. Yes.
Yeah, we can't let them film things.
I agree with that, but I think it goes to, they're asking essentially why the shooter didn't testify or other witnesses, and the defense doesn't have a burden to put any on. So we believe it's important to remind the jury that the burden is on the people and that a reasonable doubt can come from lack of evidence.
Judge, again, we can't guess what they're thinking, we just answer the questions. Judge, I'm sorry, which instructions did you?
I was thinking, well, these are the preliminary instructions 2.9 and or 3.5, was it?
Oh, 2.9 I think would be appropriate here.
I'm sorry, 2.9 and what was the other?
3.5 maybe, I don't think it says. I can bring them in and read 2.9 and 3.5 to them if you want. Three point five talks about evidence including only sworn testimony, witnesses, the exhibits admitted to evidence, or anything else I tell you to consider as evidence.
It seems on point, Judge.
I have no objection to 2.9. I am just making a record that I'm also requesting 3.2.
Okay, wait, do you want 2.9 or 3.5, either one of those? I'm trying to keep myself to answering the question that they asked. They have an instruction with them about reasonable doubt. They've heard it a bunch of times. They do not have in the jury room 2.9, although they do have 3.5. So,
Judge, the answer to the question is no, and I think reading 2.9 again and 3.5 probably appropriate given the question.
that's what I'm gonna do.
Thank you.
I'm gonna bring them in now, okay?
Thank you, Judge.
I'm sorry, what's that?
I'm gonna bring them in.
All rise for the jury.
You may be seated. And what you know, I thought it'd be easier to bring them in than try to keep you my term of handwriting. So, you asked, can we infer anything from evidence of witnesses that the prosecution did not bring? The answer is no. And you say specifically not bring in the shooter or other people who could answer how he specifically got the gun. So I'm going to take you back to our first day of trial and read you this instruction that I read you on the first day. When it's time for you to decide the case, you are only allowed to consider the evidence that was admitted in the case. Evidence includes only the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I tell you to consider as evidence. You also have a copy of 3.5, which I'm going to read to you. You don't have a copy of 2.9. That was read in the beginning of the trial. 3.5 says, when you discuss the case and decide on your verdict, you may only consider the evidence that has been properly admitted in this case. Therefore, it is important for you to understand what is evidence and what is not evidence. Evidence includes only the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I told you to consider as evidence. Many things are not evidence, and you must be careful not to consider them as such. I'll now describe some of the things that are not evidence. The fact that the defendant is charged with a crime and is on trial is not evidence. Likewise, the fact that she is charged with more than one crime is not evidence. The lawyer's statements and arguments and any commentary are not evidence. They're only meant to help you understand the evidence and each side's legal theories. You should only accept things the lawyers say that are supported by the evidence or by your own common sense and general knowledge. The lawyer's questions to the witnesses and my questions to the witnesses are also not evidence. You should consider these questions only as they give meaning to the witnesses' answers. My comments, rulings, questions, and instructions are also not evidence. It's my duty to see that the trial is conducted according to the law and tell you the law that applies to this case. However, when I make a comment or give an instruction, I'm not trying to influence your vote or express a personal opinion about the case. If you believe that I have an opinion about how you should decide this case, you must pay no attention to that opinion. You are the only judges of the facts, and you should decide this case from the evidence. At times during the trial, I've excluded evidence that was offered or stricken testimony that was heard. Do not consider those things in deciding the case. Make your decision only on the evidence that I let in and nothing else. Your decision should be based on all the evidence regardless of which party produced it. You should use your own common sense and general knowledge in weighing and judging the evidence, but you should not use any personal knowledge you may have about a place, person, or event. To repeat once more, you must decide this case based only on the evidence admitted during this trial. So I'm hoping that I helped you. All right? So I'll have you return to the jury room.
All rise for the jury.
You may be seated. The lawyer's approach on the issue I brought up previously.
Yes, sir.
All right, so it looks like they had a question essentially as to why Ethan Crumbley didn't testify in the case, which tells me that they are definitely debating this case back there. I don't believe we would say that there's any indication here that they're leaning towards a guilty verdict. I don't believe that at all. I think that there's some spirited debate. I think there's some people asking questions back there that are, again, having served on a jury, I know that that deliberations, unless there's a individual back there who brings it into the instructions and brings it into focus, you're going to have a strong possibility that you're going to get people wondering about things, just like you just heard. Why didn't he testify? And in this case, I think there's a lot. I agree with you. I absolutely agree with you. I feel like they're working through some things right now. I feel like there's a few people that are guilty or that are asking some questions, and there's some people that feel like, hey, they feel like it's guilty because of this, because of that, and as a result, right now, this is how deliberations work, and they're confused. And not to mention, again,
All right.
those instructions were very confusing. See what happens here.
You may be seated.
All right, so it appears we're back in deliberations, but I think that the state's obviously not wanting to have the instruction that Ms. Smith wanted read in regards to the fact that there is no burden, but I don't think it speaks well when they're wondering, why did the son not testify in this case? If he was, the best evidence would be the son obviously coming in and testifying that he was neglected. He obviously doesn't feel that way. And the answer to why the son doesn't testify is because he can't testify, because that wasn't the theory in the case against him. So it made no sense for him to testify, and the state did want him to testify. But the jury's back here asking questions, I believe, and I think it's interesting, the questions that they're asking. because I think it does indicate, like I said, I felt like there was going to be a situation where you're going to go back and you're going to see, like you see in the poll here, our poll. Our poll right now is 43% guilty, 43% not guilty, 14% hung jury. So we've got almost 57% leaning towards not guilty. I would agree that back in that jury room, there's going to be a few people that are going to be caught up in the emotion of the moment. And then they're going to discuss the law. And then you're going to get the people that are going to say, when you get a stronger wind back there where there's people are in one camp, that's going, in a case like this, they're going to start speaking to each other, and you're going to see um, you're certain that there's only two. Probably. I'd say probably one or two, maybe three at the start of it. And now we're probably getting down to where there's one or two people. And what they're trying to do right now is work through and the convictions of that person. And they're essentially saying, okay, tell us, why do you think she's guilty? What's drawing you here? And it's, well, because I think she could have had access to the gun, and I think it's this, and I think this could have been a theory. And the judge said, if we found this, then we have to. And they're explaining, no, no, no. That's not, the jurors that are in the not guilty camp are working through, I think, the objections and the concerns that these jurors are that are not wanting to see her walk out of the courtroom. But I think she's going to walk out of the courtroom today. I think that's what's indicating here. We'll see. There's a lot of people. I've been jumping around to different streams and checking them out. And there's a lot of people out here who want to see, who are like, the law doesn't support this verdict, but we think the defense attorney didn't do a good enough job. Listen, the defense attorney did a great job in this case. I mean, everybody has a different style. Some attorneys would have said, I wanted to focus more on explaining the law and give the jury a law course. Shannon Smith said, I want to go and focus on the emotional aspect. Remember, she picked the jury. She didn't pull a rash bomb and have a third party jury service come in and pick the jury. She knows this jury. She picked the jury. She's been doing this for years. Very experienced criminal lawyer. So she knows what's sitting in that box, and she was doing things that we couldn't understand in preparation for, in the process of this case. So I'll be back. I'm going to continue to monitor. I anticipate we might have a verdict here soon. So if we do, and I am going to have to step out of the house here for a little bit. So I'll be mobily watching, but I'll be in the comments as we're watching all of this unfold. So um, hopefully I'll be able, if the verdict comes down, hopefully I'll be able to come here and see it live with you. If not, I will absolutely make it back here. And if the verdict happens while I'm on the road, we will come back and we will certainly have a conversation at some point post verdict about our thoughts, reflections, and whether or not we think the jury got it right. So we'll go from there. All right, guys, I'll talk to you soon.
Raiders, Mark Davis and the Raiders are why we're here today. Without them and without their commitment to this community, we would not be here today. So we could not be more grateful for that partnership and more for your leadership. And Sam as the president and CEO, Sam Joffrey, that team, that trio, incredible leadership in everything that you've done. And we wouldn't be here without the people sitting here. Governor Lombardo, thank you for your leadership at the state level. Chairman Gibson, you and Clark County have been with us every step of the way. We consider it a true partnership, so thank you very much. And Steve Hill and the LBCBA,
All right, guys. So I thought I'd check back in. I'm actually getting ready to head out. So I got this stream back up. Hold on here. All right, guys. So I thought I'd check back in. I'm actually getting ready to head out. I had myself on mobile already. But it appears this stream is back up. I saw some movement. I thought, well, maybe we might be having something going on. I saw the camera shaking. The News 2 had gone over to some Super Bowl coverage. So I was off that. Then we moved over to Minneapolis 7, and now they're on some sort of press conference as well with something to do with Homeland Security. So I don't know what's going on with all that, but I'm monitoring the polls on different channels, and we're still sitting at almost 50-50. So I think this is going to be a not guilty verdict in the end, based on that last question that came in with the jury wondering. Ooh, I see somebody there. With the jury wondering about why Ethan Crumbley didn't testify, I think they're struggling back there. I think they suspect that there's a problem with this case. I don't think they like the presentation that the state put on. And I think it's very possible that we could end up with a not guilty verdict here shortly, but we'll see. And I'm gonna pin up here. Hold on a second here. I've put up in the pinned message there. I put a link to my video that I put out this morning. While you're waiting on deliberations, go over and take a look at that video. If you're watching this in replay, but it'll be up there. Put a little message. We wait. Check out. So, go check it out. I put the link in the comments there. You can click in, because I think that if that gives some good background as to why I think the jury is going to return a not guilty verdict in this case. And when they do, I think it'll be something that when people are wondering why they did, go back and watch that, because that's going to give you some explanation as to why that jury is going to acquit Miss Crumbley. But we'll see. I think she's a good attorney. I think she did a good job in this case. My opinion is, obviously styles are different things, but I think when you look at the entirety of the case, when I first started seeing things was going on, as with everybody else, a little bit perplexed. But I really think she did a fantastic job of. You have to look at the entirety of the case and what her message was, and her message was, Mrs. Crumbley is a regular person with flaws, right? You may not like her. She makes mistakes. She does things that people might dislike or disagree with, but that does not mean she's a negligent parent. And Shannon Smith did the same thing. She showed the jury flaws, everything, emotions. She reacted emotionally to the evidence in court, essentially sending the same message. You may not like me. You see that I make mistakes. I'm a parent, but just because I make mistakes, or maybe I'm not the perfect person, doesn't make me an individual that would be a negligent parent and ignore my child's signs that if I believe my child was going to do a school shooting, do you think that I would just do nothing? So I think she was trying to relate to that. I also believe that she clearly knows the jurors in that box. She's a very experienced attorney from my research that I did on her, and she has she's done a large amount of criminal cases. So she knows the juries in that area. She knows what makes them tick. She knows how to speak to them, and I think she did a very good job. I think she also did a great job pounding home the fact that the state's case, I mean, in her closing, I think she took it home. I mean, I think she really, really, really did a fantastic job of laying out the weaknesses of the state's case. So I was very impressed by the end of the trial with everything she contended with. And then on top of that, the state, I mean, the way they acted in this case, I think was terrible. Hold on one second, guys. Apologize there. I had to address a phone situation. Well, some people say she's. Well, again, um, well, I think that um, again, I think it was by design. I think that's what you have to understand. I think in this case, I think she read that the idea here is that what she was doing was the state was trying to put on an emotional case. So she was essentially communicating to the jury with her own emotions. She was showing, hey, listen, um, she was showing how passionately that she felt for her client, but she was also trying to drive home the fact that, look, I'm a reasonable individual. I'm an everyday person. I'm an everyday mom. I'm this case is about cherry picking moments from all of us, and that's what Shannon was trying to portray. And I think she read that going in there and proceed in making this a case where she tried to go in and just be the procedural lawyer, argue the law. She felt like no, she needed to kind of connect with the jury and show them that, look, let me put it on display right now. Look, this is who I am. This is what I am. And like I said, she summed it up when she began saying, hey, um, just like you may not like me, you may not agree with me, but that doesn't make me somebody that would do these type of things. And what the state basically did is she was doing demonstrating live in the courtroom the various things that this state could cherry pick and put on display and say context. Again, she made a fantastic point in context. The only thing I wish she would have done differently, or not even differently, that she might have focused a little bit more on, but I think she was caught up in the emotion of the moment. So she was focusing on how passionately she felt the state's case was weak, and it is. It's very weak, and she knows that. She's right there with that client in her hands, so she's really wanting to pound home the fact that the entire theory of this case is just ridiculous, and that's pretty much what she was trying to, I think, get across to the jury. But I wish she would have helped walk them through how they should deliberate a little bit better, knowing that these are confusing instructions, knowing that there's multiple, but taking them down each path and said, okay, path one, boom, 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 boom. If you can't find this, now she did a great job on the reasonable doubt chart. I mean, but which I really liked. I mean, like I said, her entire presentation was excellent. I mean, she did a really, really good job, while the state showed that they had no evidence, and they walk you through essentially what they were trying to do was just overwhelm the census. Look at all of this. I mean, they talked about things that had no bearing on the only question in that courtroom, and that was whether or not it was reasonably foreseeable. I mean, once you find all of the things, but where everything stops at, was this reasonably foreseeable that he would have been that she would have believed that she was dealing with the potential of a school shooting, and she took no action. And they brought in all this other stuff, like, for instance, the consciousness of guilt. The consciousness of guilt in a case like this has no bearing whatsoever. I mean, the only thing those parents were aware of is, I'm about to go to jail. I don't want to go to jail. But it didn't have anything to do with whether or not it spoke to whether or not they know they're guilty. This isn't a situation where it's like it's a whodunit, where there's a dead body over here and they're saying they had no idea. And then you find out, oh, they're planning to flee, because no, they're planning to flee in this case because they're like, holy crap, the state is coming after us. There's an angry mob of people who are angry that our son shot up a school, and they're coming with 21st century pitchforks, in the sense that they're going to lock us up, throw us in jail, put us before a jury, and they're going to do exactly what they did: show videos of the horrificness of what their son did, try to talk about the affairs, put all the warts. Look, the point of what Shannon Smith was trying to make to the jury was, we all have warts, and if we're going to go on trial because, hey, we're not the perfect parent, we're not the perfect spouse, we're not the perfect person, well, then every single person should be sitting in that chair. And she really pounded that home in the closing. So I really thought she did an excellent job doing that. Yeah. So like I said, I think she did a great job, regardless of what the press says. Um, but unfortunately, um, I don't think that people, when they're viewing these things, you know, they're they're catching snippets, and in order to understand the entirety of what's going on, you got to watch the whole thing. And that's why I said when you watch the entire trial and you get to closing argument, it all comes together. And I should guarantee you, there's 12 people in that box, when they watched the whole trial and they had her standing in front and she's tying it all up and she's making those points. And it's why we're almost 5 hours into the deliberations and there's not a verdict, because if the state had their way, the state's got to be sweating bullets right now, because the state wanted a quick verdict, because a quick verdict indicates that this jury is reacting on emotion, and that's what they wanted. And that they ran back there and said, off with her head. This woman is, just as bad. It's terrible. She let her. She didn't stop her son, and guilty, guilty, guilty. And that didn't happen. That hasn't happened. So we're still sitting here 5 hours later. The jury's trying to work through instructions. There's people back there that are. Again, you got to remember, there's always going to be a prevalence when it comes to juries, that there's going to always be some jurors on there that are going to say, well, the fact the case was made in the first place tells me there's something here. I got to figure out why. Why did the case get made? But as Shannon Smith did a fantastic job on, and she really, really, really did a fantastic job on explaining the reasonable doubt portion. And again, as I have honed in on, as I have tried to explain to people when I've talked trials and talked about perspectives, look, the reasonable doubt, the issue with trials is, reasonable doubt doesn't mean that there doesn't have to be a reason why the case was brought, but there has to be no doubt at the end of the case that the elements of the crime were committed. So, that issue alone, if you're back there and you're not certain, but you feel like, well, maybe there's a reason why, it's not your job to go further than what the evidence allows you to. If you're back there all torn up, not able to know what direction to go, just turn to the law, read your charge on reasonable doubt, and understand that what you have there is a reasonable doubt. And unfortunately, that is not your problem. That isn't the defendant's problem. There's one person or entity that has a problem in that courtroom when the jury has doubt, and that is the state, because they were responsible to eliminate doubt, reasonable doubt, not all doubt, not speculative doubt, not, well, but you're not supposed to have questions or pause when asked, do you think element 1 was met, element 2 was met, element 3 was met? You should be able to say yes, 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 walk on, and not have a problem. If you're sitting back there and saying, well, I think 1 was met, but 2 was met, but 3, man, I'm really not sure about that. Well, I mean, it could have. I mean, but at the same time, there's a reasonable explanation for why, and I can't resolve that. It's not guilty. We're not asking you to say innocent. It's just not guilty. That's it. And that's a hard thing sometimes for jurors. I don't know why this fixation of blaming only the parents, mob of peasants with pitchforks behavior. The parents are not the only two people who had influence over the kid. I agree with that. Absolutely. And as a father of teenagers, there's a lot of influence out there. And, it's disturbing, but I think it's for some reason, I think it's just a way that, it's what sells. It's what makes political careers. It's what moves the dial. But I also think it's also too that in this case, it was just convenient. I think it was a knee-jerk reaction. But what I really think it was, if you ask me, because remember, this is not the first time we had a kid show up at a school with a gun and shoot people. This was a situation, and again, this is the one thing I really wish that she would have pursued, but I'm sure she had her reasons why she didn't, because I think she probably felt like, well, maybe this isn't a route we want to go. But I feel like this this was something that should have been stated in court and should have absolutely been targeted and crossed and been a theme of the case. They didn't like the fact that Jennifer Crumbley asserted her rights for her child in that interrogation room, and that James Crumbley asserted his rights for his child, and that they didn't let him speak. And my opinion is the show of force, which I thought was absolutely crazy when you hear about what the police did. They show up at the substation. They know they're there. And you're going to tell me that these police officers didn't know before they go raid his house? They raided the house because they would have gained that cooperation. They would have gotten the right to search. They would have done it all totally differently. But they raided their house. They took their phones. They cuffed Jennifer Crumbley. They threw her in the back of a police car. And they did all of this as punishment because she dared to advocate for her child and ask for an attorney. And in my opinion, that is the real issue in this case. That's how this case ended up down the road it did. That detective, when I listened to him testify, when I listened to his reaction when she brings up an attorney, and he basically says, in a case like this, ma'am, we really would like to talk to them and find out why and find out if there's others. But you're going to assert your rights here? And it was like, yes, I am. And then they bring him in the room, and the police officer attempts to try to bring the conversation in and say, we'd like to ask some questions. And James Crumbley then steps up following the lead of his wife and says, no, I think we're going to get an attorney. We don't want questions. He's kind of looking over at her, and she's like, yeah. And then she leaves. And then when they get back in that room, it's frosty. And it's like, and James is like, is somebody at least going to say it'd be 1 or 2 days? Yeah, he's a juvenile. And then they basically say, we'll walk you out. You can tell at that particular point, the police officers involved in the case were extremely upset. They were not happy. And I guarantee you, knowing what I know about the mentality of how police officers would act in that, there's ways that they can legally address that. That they would come right at. Do I think it has to do with politics? No. I mean, I think it has to do with politics in the sense that they're pursuing it. That some of the mentality of that comes from the willingness of people to hold people accountable, and the pitchfork peasant mentality, I think, comes from it's easy. It's easy to get people's ire up. It's easy to get people's emotions up. So I believe that there's a political motivation there from the fact that the individuals that win this case will move up the political spectrum from maybe becoming judges to, pursuing higher office. That always seems to happen. That's always seems to be the mentality of the individuals that are state attorneys. They're wanting to move up to bureaucratic, the bureaucratic positions. So for them, one of the ways to do that, especially if you want to move into a judgeship, get on the appeals court, maybe become the head of the district attorney's office, is, hey, win the big cases. So this case is attractive because it's an emotional case, and people will remember you got justice for the victims in this case, and that's attractive to anybody who wants to run out there and say, I did that. I get credit for that. But I think the genesis of this case resides in one place. The police's frustration, or the fact that the Crumbleys didn't cooperate and didn't say, oh my God, I can't believe my son did this. I'll turn it all over to you. Here's our phones. Here's our house. Here's everything. So they said, fine. You want to be against us? You want to assert attorneys? We'll show you what that looks like. We'll raid your house. We'll take your phones. We'll put you in handcuffs. Because like she said, what the hell am I in handcuffs for? I was just at the substation. She said, well, we don't know. I mean, they came and put guns in his father's face. And they said, well, since you're not cooperating with us, we have to assume you're against us. We don't know if you're at the house with firearms in the house. We don't know what's going on. So we're going to treat you like an enemy. And that's what they did. And they were an enemy from then forth. And then as they start digging in and finding the salacious details of her life, finding out, again, they didn't like her attitude. They didn't like, they just didn't like her. So as a result, this thing gets legs, and they think something's there. They think that, hey, you know what? She's not a good person. I can see she's not likable. So you're going to protect your son. You're going to go do this, well, then reap the consequences. Fine. We'll hold you accountable. And then, of course, these type of things get rolling, and then there isn't a way to roll it back at a certain level. And that's what happened in this case. And then you end up in trial with a bad case, stretching the facts, stretching the evidence, trying to make the law fit. And guess what? Hopefully it doesn't. Hopefully it doesn't. Well, I think, yeah, the longer it goes, absolutely. But I think the longer it goes, listen, I can tell you from when I was on a jury, uh, we had one person, well, we went from 10 to 2 guilty. It flipped around to, we ended up in a compromise verdict situation, but it essentially was akin to a not guilty verdict for the defendant. And we went from 10 to 2, where the entire jury was guilty, as we talked more, and we deliberated for, I'd say, about 8 hours. And it slowly was changing. And there was one person in there that everybody was talking to and going over with things. And eventually that person came around. Um, you know, Sometimes, though, I think there's an appeal that a lot of times jurors don't want to hand this off to somebody else. They want to get the job done. So I think when somebody sees, unless it's just something, and in a case like this, I think it's such a close call that you're going to get more chance of moving to the other side on something like this. That person's going to say, you know what, fine. If I got 11 people back here that are saying not guilty, we're moving to not guilty. And the same can happen on the guilty side. Although on the guilty side, I think people are more likely to dig in when it's say 11 to 1 guilty, because the guilty person understands that they're literally a gatekeeper. They know what's going to happen to that defendant if they relent. So I think a lot of times people are like, you know what, I'm not giving up. Like, I feel this way, you 11 don't. I'm standing tall, and onward we go. Um, you know. But what happens if it's 11 to 1 majority? No. If it's 11 to 1, it's a hung jury. That means they go home. That means they do it again. So it's got to be a unanimous verdict. In the United States, it's got to be a unanimous verdict. You have to have 12 jurors voting one way or the other. Otherwise, it's what's known as a hung jury. But we're far away from that, because what will happen is, if it does get to a point where they feel like they've come to a point that they can't break the tie, they're going to bring them out. They're going to do what's called an Allen charge. Allen charge is where the judge is going to give it. It's a prefixed uh, instruction that just basically says, I implore you to go back and give it another try. And what I would ask you to do is each of you go around the room and discuss your concerns or hesitations with your position. In other words, don't discuss why you say not guilty. Discuss why you would say opposite of that. And inside that discussion, see if that opens up any opportunity or avenue for change, or to get across the line. Once you've done that, if you still feel that you're deadlocked, then at that point, you come out and you let me know, and I'll declare a mistrial. And once an Allen charge is given, there's no going back. In other words, if they go back and do that, whether it's 10 minutes later, 20 minutes later, 3 hours later, when the jury comes back out and says we're done, they're done. Now, there is some case law that says that the judge, if it's late in the day, the judge could say, all right, listen, thank you very much. What I'm going to do is I'm going to have you go home. I'm going to have you sleep on it, have you come back in the morning, and then you come back together and see if you're still deadlocked, or see if anybody's had a change of heart overnight. If not, then we'll call it at that time. It's a little bit risky to do that. There is case law supporting that, but there is potential for reversal within that. It's a challengeable situation. But most of the time, the judge, after the Allen charges, the jury comes back and says it's done. And again, in that case, the defense would want to, if either side has issue with that, you saw that in the Tyrone Tucker case, but if either side has issue with it, they normally will just say mistrial and send them home. But if you don't get 12 jurors voting either guilty or not guilty, it's it's a mistrial. It's a mistrial. All right, let's see what's going on back over here. There's nothing. I'm gonna make sure we're live on this. Yes, we are. All right, so I've got to step out for a little bit, guys. I'll be back. We'll see if we have a verdict by the time I get back. I've got about little over 2 hours left of the stream, which will bring us to probably about almost 4:45, 5 o'clock. I don't know if this judge is going to go later or they will end the day and let them come back in the morning if they go too late. But we'll find out. So appreciate you guys sticking with me. Like I said, click the link, watch I pinned the link to my latest video. Watch that. I think it's an interesting watch. It'll give you something to think about. Let me know your thoughts. And then, of course, don't forget to like the stream, get it out there. Don't forget to share it too as well. Let people know we're watching over here. I'd love to get as many people into our poll as possible. Right now, our poll is 39% guilty, 48% not guilty, and 13% hung jury. We've got 23 votes. So we are sitting at 61% right now in the not guilty or hung jury category. That is very strong. I'd love to get more votes in there. So if you do anything you can to get people in here, at least to give their vote, drop a comment, join us in deliberations, and I will be back soon. Like I said, I've got to step out, and I'll be back in a little while. All right, guys, happy deliberations, and I'll be in the chat, of course, as well, monitoring the chat and answering questions in the chat. So feel free to chat in, ask questions, and we'll go from there.
Your Honor, calling People versus Jennifer Crumbley, case number 222799990 FH.
Chair McDonald, appearing on behalf of the people.
Thank you, Mark Keith, on behalf of the people.
Thank you, Shannon Smith, on behalf of Jennifer Crumbley, who sits to my left.
All right, we have been in contact with the jury. They said they want to stay till 4:45 and that they probably want to come back tomorrow. But unless there's an objection, I might release two of the other 5 sequestered jurors and tell them that they're sequestered at their home. Do you object to that?
Not at all.
No.
No objection.
We've given them puzzles and Sudoku and that they're probably losing their minds. So I was going to release 2 or 3 and have them go about their business, but they would still be sequestered. So they would still be subject to sequestration of the court and not be permitted to be spoken to by anyone, right?
Yes, sir.
All right. Any preference, 2, 3?
If that's so reliable, Your Honor, I'd say 3.
Can we approach her?
Sure. You may be seated. I know you guys have all had an exciting day. We've completed puzzles, done Sudoku. I heard one of you was sleeping on the floor. I won't name names or pick on any of you. I'm so sorry. Hopefully you realize the reason behind it. Okay, so here, the 12 of you have not come to a verdict yet, so they're going to be returned tomorrow. But life happens, and in the event that one of those jurors was indisposed, we would need one of you to fill in for them, and they would be instructed to start deliberations all the way over again. So that's the reason for it. That being said, I'm going to dismiss 3 of you by blind draw today. Actually, I shouldn't use the word dismiss. I'm going to have 3 of you not return tomorrow, but you're still sequestered. You understand what I'm saying? So some of these people sitting out here would love to talk to you, but they are not allowed to talk to you when you're not allowed to talk to them. And it's the same as every day when you leave here. You're still sequestered. I just think that you would prefer to be doing your laundry or going to work or doing whatever it is, but I still have to trust you to not discuss the case. All right? Are there any questions about that? but I'm gonna have two of you come back. I think you've already ordered your lunch, so I'm hoping the three of you ordered something we like. No? No? Yeah.
My question is, if we are one of the three that go home and spend the day at home tomorrow, how do you know if will you call us as soon and let us know what to do the following day?
Absolutely. I feel bad enough that I feel like I kidnapped you. Okay, so I feel bad enough that you're here. I know that you know why. Okay, because you know, when this is all over, I'll tell you stories about strange things that happen and jurors and, you know, just life happens. So, as you know, this is a very long, emotional, and frankly expensive process. To start over would be devastating for everyone in the room. So, I appreciate you. I feel bad, but I would feel worse if we didn't have enough jurors to finish deliberations, okay? So, three of you, I'm gonna pick three numbers by blind draw, and then you can exit, and they're gonna take you down to your car. And we have your phone numbers. You are still sequestered, all of you, and the other two have to return back in the morning, okay? And I'm gonna tell you again that during the trial, do not read, listen to, or watch any news reports about the case. Under the law, the evidence you consider to decide the case must meet certain standards. For example, witnesses must swear to tell the truth, and the lawyers must be able to cross-examine them. Because news reports do not have to meet these standards, they could give you incorrect or misleading information that might unfairly favor one side. So to be fair to both sides, you must follow this instruction. So do not go on social media, don't post anything to go on Facebook, don't do research, don't discuss the case with anyone, whether you're at home or at work or here spending the day with me again, all right? So I'm gonna pick three of you by blind draw, the other two have to return at 9 o'clock in the morning, all right? Juror 17, you can be sequestered at home. Juror in seat 4, you can be sequestered at home. And juror in seat 10, you can be sequestered at home. All right? You can bring things with you. You're 9 and 15. Jurors in seat 9 and 15. I mean, obviously you can't bring a newspaper or something like that. You still can't research the case, but if you have work, you can finish my crocheting for me, if you know how to crochet, you know, anything like that. I know it has to be really boring, but I think you understand the purpose. You can't talk to anybody. Again, a lot of people here would love to talk to you, but none of you are allowed to talk to the press or discuss the case with anyone. All right? And we do have your phone numbers. So I'm going to release you to go back to Judge Anderson's jury room, and then you're going to be escorted out of the building, and then the two remaining jurors, if you could come here at 9 o'clock tomorrow morning. All right? Any questions about that? Okay. We appreciate you. Thank you for understanding.
All rise for the jury.
Okay, now I'm going to read another jury, and if you can all be seated.
like 9? 9 is good.
9 o'clock? Okay, you're gonna return tomorrow at 9 o'clock. We appreciate your efforts, we appreciate you taking this seriously, this is very serious, as you know. And I need to tell you that during the trial, do not read, listen to, watch any news reports about the case. Under the law, the evidence you consider to decide the case must meet certain standards. For example, witnesses must swear to tell the truth, and the lawyers must be able to cross-examine them. Because news reports do not have to meet these standards, they will give you incorrect or misleading information that might unfairly favor one side. So to be fair to both sides, you must follow this instruction. Do not go on social media, don't post, don't go on Facebook, don't do research, don't discuss the case with anyone. All right? Any questions about the schedule? We'll be kind of at your will, so get a good night's sleep. Maybe sleeping on it will help you, right? Stay healthy. We appreciate you, and we'll see you at 9 o'clock, right?
All rise for the jury.
I'll let the jury go first. 'Cause maybe see. I just want to make sure that the jury, both sets of jurors are on. So we'll see you at 9 o'clock in the morning.
Yes, thank you.
I'm just gonna make sure.